Okay, right there, you just if you click on the three dots all the way to the right, then no, up there,
Oh,
there, yeah, and then you can do like full screen, like this. See where it says zoom? If you
yes.
in that, yeah,
Aha.
okay, awesome, perfect. So and then also I'm pretty sure that right there, if you click on that, I mean that is gonna be fine for us. But if you click on that, probably in the three dots right there, probably it's gonna be a full screen also.
Yeah.
No, so then try to do a right click right there in the top. No, no, in the like right there. No, no full there you go. Set full screen. Right there, the first one. The first one.
Oh, it says exit full screen.
Oh, okay, okay. So then that's it.
Yeah, so this is the full screen.
Okay, okay.
It's a PDF, so oh
Oh,
well.
that's where we see some menu right there. Yeah. Okay. Perfect. I mean, not the menu, but the. Okay. Perfect. All right. So I'm gonna get some water just in case that somebody needs help.
Okay, perfect.
Okay. Thank you, Rochelle.
Thank you.
Okay, so I'm going to spotlight myself again for a minute, and we're going to get started in about 3 minutes.
Perfect. I'm gonna go grab some coffee.
Hope everybody's joining. We're up to 30 so far. Rochelle?
Yes.
I just want to let you know that if you want to take questions, you're probably aware of this, but I'm going to say it anyway. If you want to take questions, there's two ways that participants can communicate. They can chat, and if it's okay with you, as people ask questions, I might, and you tell me if you don't want to take any questions until the end, that's fine. But as people chat questions, I might interrupt you and just say, hey, we have a question from so-and-so. And people can either chat the question, or you could invite them to ask a question by by unmuting themselves and then asking the question, whichever you want to do.
Cool. Yeah, I like questions. Questions are great. Because I'm in the full screen mode, I can't really see what my chat bar. So yeah.
I'll alert you to when there are questions. Cool. But you might, in your intro, you might want to just mention that, yeah, if you have questions, go ahead and, either, chat them in, and then Don will let me know that there's a question for me.
Perfect.
Okay. All right. So one more minute and we'll turn this on. And right now we have 37 people online so far, but I expect a few more than that.
Cool.
Yeah, so far these little webinars, I mean, I had zero experience with doing these things until last year. We did 3 of them last year, after COVID started, and everybody, they went pretty well, but I'll continue doing them. However, I look forward to just getting back to the in-person things,
Yes. Yeah, I know in some ways the virtual allows more people to attend, but in others, there's just not as much as participation.
Right. All right. So you ready to get going?
Yes.
So your screen is like frozen in my computer. Rochelle, you can see that the Dawn screen is frozen.
No, it's not. I didn't see it frozen.
Okay, perfect. Then it's just me, so that's okay.
Okay, so I'm going to admit everybody and get started.
Okay, I'm gonna mute myself and I turn my camera off, but I'm gonna be around.
Perfect.
Okay.
All right. Good luck, Don.
No.
Okay.
What the hell? Let's see.
Good morning, everyone. We're going to get started in just a few seconds. There's still people joining into the webinar, but so I'll give it just a couple more minutes. But everybody that has already joined, if you would please mute yourselves. I can hear some people, their background, so please mute yourself.
John, there is a function that you can mute everyone.
Yeah, I know.
Okay.
Okay. All right, everybody. I think we're going to get started. I think I have one more person to admit. Okay. Well, I want to welcome everyone to, I want to wish everybody a good morning and welcome everyone to the second of what will be 4 AAIP continuing education webinars. I'm Don Stewart. I'm president of the Arizona Association of Independent Paralegals. As I'm sure most of you are aware, we're the professional association for certified legal document preparers here in the state of Arizona. I'll just kind of jump right into what we'll be doing today. We have a terrific lineup of speakers today. We're going to start off with attorney Rochelle Polton. Rochelle is going to present on the topic of civil litigation, plain defense and debt collection lawsuits, including her presentation. She's going to go over some basics of civil litigation all the way to kind of a deep dive into some of the complicated aspects of litigation. Our second speaker, Rochelle will be speaking for 2 hours. Our second speaker will be attorney Tom Alonji. For those of you that have been coming to our seminars for years, Tom has spoken to our association on several occasions. He's going to be giving us a family law update. And so that's always good. Again, Tom's presentation is about 2 hours. And then the last hour, I'll be speaking on CLDP ethics with a little bit of a focus on communication and remote services. I look forward to our presentations. They should be excellent as they always are. A little note that I do have the materials from all our presenters, and I will be sending those to all of you along with your certificates of completion, which, and along that line, as was detailed in the attendance instructions that I sent out to everybody, I have the way that I verify attendance is that throughout the webinar, at random times, I will show all the participants a word, and there'll be 3 verification words that I'll show throughout the webinar. I'll take my time showing them. I'll spell out what it says if any of you are attending just by audio. You want to write down these words, and then at the end of the webinar, send me an email, respond to the attendance email that I sent everyone, or just otherwise send me an email. and tell me what those 3 words are. And in response, I will send you the certificate of completion along with the handouts that each of the presenters have provided me. And then just a couple little notes. Number one, try to make sure that you keep yourself muted throughout the webinar. Now, the presenters, since they have their the materials that they're sharing on the screen, they can't. I don't know that they can see when someone has a question. So if you have a question, you are welcome to use the chat feature on Teams. I can hear some people. Please, everybody, mute themselves. What I was saying is that use the chat feature to ask questions, and I will relay that question to the presenter. Or if the presenter wants, the presenter may ask people to just to raise their hand. And hopefully you all know that little raise your hand feature, and then the presenter can choose to call on anybody that might have a question. Let's see. Okay, so without further ado, I am going to go ahead and spotlight Rochelle Poulton. If you give me just a second, and we'll get started on her presentation. Just a minute, please. I have so many people in here, I can't find, oh, there she is. Okay.
Hello.
Just a second. So I'm going to spotlight you. All right. So take it away, Rochelle. Thank you.
Awesome. Thanks so much, Don. It's always a pleasure being here. So my name is Rochelle Poulton. Everybody hear me okay?
I think so.
Perfect. Yeah, so if you've got questions, you can put them in the chat. And Don, if you wouldn't mind just letting me know that there are questions. I can't see the chat when I'm in present mode.
Absolutely.
Okay, so again, my name is Rochelle Poulton. I'm an attorney. I'll be joining Poulton and Noroyan in April next month, doing more business litigation and real estate law related litigation. But for the past almost 10 years, I've been helping people with consumer rights issues. So I've been doing a lot of debt settlement, credit repair, bankruptcy, debt collection, litigation defense, obviously a lot of that, but also handling Fair Credit Reporting Act and Fair Debt Collection Practices Act litigation. And it's been a lot of fun. But it's, time to switch gears. So I still will be doing a lot of litigation, but one of the things that I think is important and what we need in our industry as a whole is more people assisting debtors when they get sued by debt collectors. And that'll be the focus of today, is covering a lot of those bases. I love to do these kinds of presentations. I do a lot of continuing legal education for attorneys. I wrote a book. I have a podcast called Legitimate. You can find it on Spotify. So that's enough about me. Let's get into the topic. Today's agenda. So we're going to cover 6 parts. One is, what is debt collection, which is just a basic overview of debt, how we got here, why we're here today. And then a quick primer on Justice Court versus Superior Court. The litigation process is where we'll spend the bulk of our time today, just going through that in whole. I'm not sure how many of you have actually seen the litigation process, but it's a good oversimplified version of what to expect. And then, of course, the most common types of debt collection lawsuits there are, and then the top defenses that people should consider pursuing when they're sued by a debt collector, and, of course, possible outcomes. So we'll take a break around part 3 for like 5 minutes, bathroom break, coffee break, whatever you need. So don't worry, I won't talk for a straight 2 hours. All right, so let's get into it. First up, let's talk about debt. Right now, there is about $7.3 trillion in consumer debt in the United States, and that's excluding mortgage debt, which is about $10.4 trillion. So total, we're looking at almost $20 trillion. It's a lot. And on this pie chart, I've broken down where the debt is. So as you can see, the leading category is student loan debt at 1.2 trillion. It's probably closer to 1.7. Car loan debt is about 1.7. Medical is 45 billion, and credit cards is a mere $915 billion. It's a lot of money. There's a ton of debt hanging out there. It's a big problem. Only when you really think about how are you going to pay it back. So debt based on generation, it's helpful to see who's got how much debt. So this is like average household debt based on age. So as you can see, millennials, which is ages 25 to 40, have about $78,000. Gen X has 135, and of course the baby boomers are at 96, and the silent generation is 75 plus, still carrying about $40,000 in debt. A lot of that includes, of course, mortgages, car payments, student loans. That's really the primary, but then, of course, credit cards and some medical. So typically, when you're dealing with debt and debt collection, there is a cycle to all debt. Usually you're obtaining debt, you're paying off debt, and then you pay it off and you close the debt, and then, of course, you get more debt. That's just how our debt cycle in the U.S. works. But where people kind of detour on paying off their debt is when they have life happens. Like, it just happens to everybody. Obviously, we had this pandemic that just occurred where a lot of people are currently in default on things like rental payments, car payments, student loan payments, but there's moratoriums on a lot of things. So there isn't this pressing need to resolve it for the time being. But the top 4 reasons people end up defaulting on debt is because of a reduction in household income, which usually happens when someone breaks up, a roommate moves out, or you get divorced. When people get divorced, they have half the income and the exact same amount of expenses, and it can be a huge financial burden and an unexpected, unanticipated loss. Of course, job loss. People have gotten laid off permanently, terminated, they seek a lateral move, they start a new business. There's a lot of reasons why people can have a reduction in household income. But then the second thing that really people can't anticipate are medical issues, usually illness or injury. Sometimes a car accident will cause way more damage than people anticipate, and they're looking at not being able to sit behind a desk anymore or do manual labor anymore, whatever the case may be. Injuries and, of course, illnesses, cancer being one of the number 1 reasons why people end up defaulting on debt. It's really sad. And unexpected expenses. So this would be, your AC repair, your roof leaks, your needing new tires on the car. There's a billion things that fall under unexpected expenses that just kind of wreck someone's monthly budget. And last but not least, identity theft. Identity theft happens. It's a lottery that everyone will win. The only question is when. All of your information's out there. It's only a matter of time before someone takes it and uses it against you. So that's the unfortunate reality of the debt cycle, is how all of this plays together. People being in debt, people getting sued by debt collectors, doesn't mean they're a bad person. It just means they had a bad time. So let's get the judgment-free zone today. So what is debt collection really? Right now in the U.S., there are 6,724 debt collection agencies as of 2020. It has reduced in recent years. It used to be closer to like 8,000 or 9,000. But last year, it was estimated, or in 2017, it was estimated that 70 million Americans were contacted by debt collectors, which is about half of the adult population. So collection industry personnel went to the Consumer Financial Protection Bureau to request permission to increase the number of calls they're allowed to make a day on each account. So they wanted to do 6 calls a day, 186 calls a month, and 2,190 calls a year for each account. So if you're one of those people that, I think we all get miscellaneous spam calls every now and again, but when debt collectors are calling, it feels incessant. Representing consumers who were dealing with debt issues, some of my clients were getting 50, 60 phone calls a day from multiple creditors. It was just insane. People just stop answering the phone for, unknown phone calls, which, forces people to kind of miss out on really important phone calls from, family members and whatever, because they're afraid to answer their phone. So it's a pretty big deal to have this many phone calls, kind of spread at you. But now, you've got text messaging and emails, et cetera. So there's a lot of communication that happens. So there used to be a trend, you know, backup. What is debt collection? In 2019, why do people call so much? Because the industry is worth $12.7 billion in 2019. It is trending up. That is a lot of money. But if you remember, there's about 7 trillion in debt that people could actually default on. So what people are collecting on versus what's out there that could potentially be collected on in the future, there's no reason to think that the collection industry is going to stop being successful. And here, when there is money, there are lawyers. And so we find ourselves these days with the rise of the debt collection law firm. Several years ago, there were only a handful of law firms that were representing collection agencies in debt collection matters. But now the majority of law firms have a debt collection division. So it's kind of problematic because a lot of law firms just don't represent consumers in debt collection lawsuits. It's cost prohibitive for the consumer to pay a lawyer in many cases to defend against a lawsuit. But when you're on the debt collection side as an attorney, they usually charge some kind of contingency fee, or you're allowed to do it, or better yet, you collect your attorney's fees when you get a judgment. So there's been this flock of lawyers into debt collection. So you'll see some pretty high-powered law firms, handling a Wells Fargo account in justice court for $3,500. It's kind of insane. So before, a lot of people just thought, well, the statute of limitations, I don't need to pay my debt because eventually it'll expire. The statute of limitations is out there. So let's do a quick chat on what is the statute of limitations. The statute of limitations is, a limitation on how long a company has to sue somebody for a debt. There are statute of limitations on various things, but what we're talking about today is liability on consumer debt. And this is a very brief overview of what they are. So for credit card debt, it is 6 years from the date of last payment. So if someone had a credit card back in 2012 and they stopped paying on it, well, it's been 8 years. It shouldn't even be on their credit report anymore. So, they may be getting calls from like Portfolio Recovery or Calvary Portfolio or any one of the billions of lawsuits or debt collectors that collect on what we call junk debt or expired debt or out of status debt, whatever. It's only 6 years. For medical debt, it can be 3 years or 6 years, depending on whether or not there was a written contract. A lot of the times when people go to an emergency room, they're not actually signing off on the financial authorization paperwork, which makes it an oral contract instead of a written contract. And sometimes there's third-party providers that are providing medical services to people, but obviously they don't have a contract with the person. So even though they don't have an oral contract, they still have a claim for unjust enrichment, which is still probably about 3 years. And then all vehicle debt is 4 years. It is not contract debt. It's subject to the Uniform Commercial Code, or the UCC. It is a sale of goods. So it is only a 4-year statute of limitations. And of course, private student loan debt is 6 years. It itself is another contract. But this is only in Arizona. So which statute of limitations apply in any debt is going to be based on state and debt type. So calculating when a statute of limitations runs or when it starts is a legal question. You can't just assume that because it's X years old that it's expired. A lot of things can come into play and affect whether or not a statute of limitations has been told. For instance, sometimes people will get into a voluntary payment plan. on a debt. And even though they defaulted on it back in 2012, they started making payments on it in 2014. They stopped paying again. They started making payments again in 2017. They stopped paying again. They started paying again in 2019. They stopped paying again. Well, that all reset the statute of limitations over and over and over again. So that's how you can have a super old debt still popping up on your credit report, and, still getting sued. So people really used to rely on this. And up until I would say about 2013, waiting it out was a fair approach to avoiding paying your debt. It was very common for credit card companies to not sue, for medical to not sue, for vehicles to not sue, for private student loans to not sue. And so a big part of the credit repair industry was just disputing all of these old debts, getting them off people's credit reports so they could improve their credit. But game has changed because debt collection lawsuits are the new reality. Like I said, where there's money, there's lawyers. And, that's just how they work. They want to protect their clients. There's a need for representation, and there's people that can pay them. So as attorneys, we know the law, so we use it. And we can take all of those debts, and no matter what those SOLs were, and turn them into judgments. And once they become a judgment, you get 10 years to enforce collection on the judgment. Up until August 3rd of 2018, it was only 5 years. It was a Senate bill that passed. I've included it in the materials. All of this information in way more detail is in the actual presentation itself in the written materials, just FYI, in case you're furiously taking notes. And I footnoted everything with a reference to all the statutes. And the statutes are attached as well. But the 10-year SOL period is new in Arizona. So if you had a judgment that happened back in 2016, it would have expired in 2021, but the reality is it's not going to expire until, 2026, and then it can be renewed for another 10 years, and then probably another 10 years, and then probably. That has not been litigated yet in Arizona, whether or not they can renew these things indefinitely, or whether, you only get a couple of bites at the apple. But the reality is it's probably a lifetime. So once there is a judgment, it is a problem because it becomes a judgment lien if they record it. So a judgment lien is when the judgment itself gets recorded in the Maricopa County Recorder's Office or whatever county the person resides, and it attaches essentially to any personal and real estate property against the person. Well, just real estate property. So if a person owns a house in Maricopa County and there's a credit card judgment from 2016 recorded, well, if they ever want to buy a new house or refinance, it's a lien against their property. So they will need to satisfy that lien. Of course, there's homestead exemptions and bankruptcy and all sorts of complicated legal analysis on whether or not that has to be paid, but that is a totally separate CLE. When it comes to wage garnishment, they can also garnish your wages once they get a judgment. It's a separate court action. They still have to file more paperwork to do it, but they can and they will. And account levies are just basically bank account levies. If you own a business, they may try to come after some of your business assets if it was a business credit card. And then, of course, levies against personal property would be, selling your printer. It's rare that people personally have levies against personal property. I really only see it against investment homes and things like that. It's a pretty big deal. So don't think those judgments don't matter. So what's really the big problem with these judgments that result? Two parts: post-judgment interest, and of course, when they become a judgment lien. We just covered judgment lien, so let me talk and tell you a little story about post-judgment interest. What happens when a credit card company gets a judgment against a debtor or, a vehicle repossession company or whatever, pick your debt? They are entitled under the contract to post-judgment interest at the contract rate. So what you typically will see is some default contract rate of 18%, maybe even 29%. In some particularly egregious cases where it was a title loan, maybe 399%. So you have, what used to be a $1,000 credit card in justice court, fast forward 10 years, is now, a $30,000 lien against someone's assets. it's pretty terrifying to see how these things grow. I've seen cases where a debt for $13,000 became $80,000. Wages are still being garnished. It's just insane how much post-judgment interest just compounds a debt every year. And, it doesn't matter if the debt collector sat on it and didn't really do anything to enforce collection for 5 or 6 years. What matters is they have a judgment and they're legally entitled to collect. They can collect attorney's fees. They can collect pre-judgment interest in some cases, post-judgment interest in every case, along with court costs and reasonable costs. So, a $3,500 judgment could very easily become $7 or $8 grand simply by not addressing it. So when you see someone who says, I've been sued, it is a really big deal, and it's really important to address it and not let it kind of just hang out there. Obviously, one option to avoiding a debt collection lawsuit is to file bankruptcy. But what we've seen in the last couple of years is a trend down. So in 2011 was kind of our peak in Arizona in the last couple decades on bankruptcy. There were about 35,000 cases filed in Arizona. And by 2015, it dropped to 15,000, and it's just been sort of declining. Last year, it was only 9,300. It seems kind of weird, right? Because we were in the middle of a pandemic. There's, COVID-19. People are losing jobs. People aren't able to pay their mortgages, their rent payments, their student loans, in some cases, their car payments, their credit cards. So why aren't people filing for bankruptcy? Well, mostly because people think things are going to get worse. They don't know where this is going to end. They don't know when their jobs may come back, or if they'll be in a position to pay things off later, or if they're going to get sick and have medical bills. There's a lot of uncertainty, which is, causing people to really not take advantage of bankruptcy protection because you don't want to file too soon. Sometimes you are better off just waiting to see whether or not anything else is coming down the pipeline before you use your Chapter 7 bankruptcy to get a clean slate and move forward. The last thing anybody wants is to file for bankruptcy protection and then get slapped with a $100,000 medical bill because you can't discharge it again. You're just kind of stuck with the debt. So in 2021, in January, we had a 37% decrease in the number of in the number of bankruptcy filings in the state of Arizona from 2020. So we're on track this year already for only 6,200 filings. So for people who are thinking, bankruptcy is a great industry to get into, I'm going to make a ton of money. As you can see, the numbers are trending down. Obviously, they're going to trim back up, but when that'll happen, who knows? If we could only see the future, we could all make better decisions, right? So let's start on part 2, unless anybody's got any questions. Perfect. Part 2, Justice Court versus Superior Court. The main things you need to know about Justice Court and Superior Court is that every county has one. So when someone gets sued, it's important to remember, one, where did they get sued and who has jurisdiction? And so the easiest way to think about jurisdiction is to think about dollar limits in debt collection lawsuits. So it's anything under $3,500 can be filed in small claims court or justice court. So if it's an individual doing it in small claims court, there are 2 things to remember. One, you can't appeal and the decision, and you just can't. Like, once it's in, that's the end of it. There's no fighting back. In justice court, it is up to $10,000, and superior court is anything over $10,000. Sometimes things that are under 10 grand get kicked to superior court because there's another issue involved. Like when there's a counterclaim for Fair Debt Collection Practices Act cases, a lot of the time the plaintiff will argue that it should be a superior court case, whatever. So justice court and superior court are really where you want to take note of where these things are being filed. And then venue is really based on county and location. So if someone gets sued in Maricopa County, but they live in Pima County, there's an issue. Like, they should have been sued in Pima County, obviously not Maricopa. But then, paying attention to which court. In justice court, there's a lot of different divisions. There's like Arcadia and Dreamy Draw. So making sure you're filing things in the right place really matters quite a bit. Thankfully, in 2020, the local court system started accepting digital filings. So you don't have to drive to the justice court anymore to file any pleading. You can do it via email or over the fax. You need to definitely call them in advance, confirm how they're accepting the filing, and then of course you do have to call justice court back to pay any filing fees. You do have to pay a filing fee when filing an answer. If you don't pay the fee, the answer doesn't count. So you'll end up with a default judgment. So pro tip, don't forget to pay those filing fees. You do have to call the court and do it. In Superior Court, all of those are online. They use Turbo Court. You can start a case that way now. That's nice. But just remember, pay attention to jurisdiction and venue when you're looking at these debt collection cases if you're thinking about helping people. The other big key to civil litigation is to play by the rules. And there are a lot of rules. And for Superior Court, you're going to be looking at the Arizona Rules of Civil Procedure. And for Justice Court, you're going to look at the Justice Court Rules of Civil Procedure. In the materials and one of the footnotes, I did put a link to the source that's online for free that gives you all of the rules of civil procedure for all of the courts, including all of the local courts. You're welcome. So knowing that this is where the rule book is worth its weight in gold. It gives you the form of pleading, so it tells you what types, what font size you can use, what the margins on your pages should be, how many lines you can have. Like, it's so useful to be able to have that kind of direction in one place. Your response deadlines are all found in the rules, and it depends on which court you're in, when your answer's due, what your response deadline is to a motion, when you can file certain types of motions. So this is where you can find those sorts of rules. Disclosures that are required. In Arizona, we always want to fully disclose. So even if you're the defendant in a litigation case, you still need to file disclosures. They're called your initial disclosures, and the form and what's required is in the rules. And they're really quick and easy once you know where to find them. And then there's limitations on discovery. You can't send endless questions. You can't take 1 billion depositions. You can't take 20-hour depositions. All of that is in the rules. And then, of course, your arbitration procedure. If you're in Superior Court and there is compulsory arbitration, the rules are in there. Like, I've again cited all of these in the footnotes, but knowing when and how to participate in these processes is really, really important, because litigation doesn't end when you file an answer. That's when it begins. And there's so many things that happen once someone decides that they're going to fight a lawsuit. So first up, the litigation process. Yes.
Rochelle,
yeah.
I'm sorry. Can you see when the hand is raised?
No, I can't.
No? Okay. All right. There was a question. Nicole wanted to know if you have to be a licensed attorney to use the electronic filing options for the court.
I am not sure. I don't think, because some people who represent themselves pro per have used Turbo Court. I'm not entirely sure how they were able to do that, but I have seen it done. I'm not sure if it was accepted, but I don't actually know.
Okay, well, that might be something I can check out for people. I'll see what I can find out.
Yeah.
If anybody else that's attending knows, please put it in the chat. Thank you.
Yeah, that was a fair question. Sorry, I don't know that one. Okay. So the litigation process, this is a really oversimplification. The full chart is actually in the materials as well, but you've always got a plaintiff and a defendant. Usually the plaintiff is going to be the debt collection company or the owner of the debt. Usually, sometimes the debt collection company owns the debt. Sometimes, it's still Capital One. Who knows? We're just picking on random companies today. And the defendant is always going to be your debtor. So the plaintiff is usually represented by an attorney. There are a lot of law firms that handle these kinds of cases, but the big ones are like Gerstel Law, James R. Vaughn, the Law Office of James R. Vaughn, Moore Law Group. There's tons of them, but those are the three that you're probably going to see more often than not, because they do handle a lot of the big client cases for like American Express and Capital One. And then there are a lot more. There's just a lot, but those are usually the ones you're going to see in a credit card case. So every case starts with a summons and a complaint. That's what kicks it off. It says, hi, I'm summoning you to court, and I have a lot to say that you owe me money. And that's what the complaint is. It just dictates, it says specifically why we're here. So it'll name the parties, it'll say which court you're supposed to be in, which venue is proper, who they're suing, and why they're suing, and more importantly, how much they're suing for. So knowing how much they're suing for and what they're suing for is really, really important when you're deciding whether or not it's worth it to go through the litigation process. If it's a case for $1,000, do you really want to do the next 15 steps that come after this? Maybe not. But, in some cases when it's not you and it's not your debt, and, there are a lot of great principal arguments for fighting these kinds of lawsuits. Great. If none of those exist, you're better off negotiating a settlement. But every lawsuit starts with a summons and complaint, whether it's in Superior Court or Justice Court. And then comes service of process. And service of process is just serving someone with the lawsuit. And there's personal service and there's alternative service. Personal service is when someone hands you the lawsuit, and personal service can just be handing someone in your household the lawsuit. People get offended when process servers serve their 14-year-old children. Well, that's allowed, if they're, appear competent and able to accept service and will very obviously give it to their parents. Courts generally uphold that. I know it's offensive, but that's how it is. You don't have to be over 18. You just have to be competent. And competence is something that they certify when they file their affidavit of service. Alternative service is when they can't really locate you. So they may send it to your last known address. They may just post it on your door because they know you live there, but you haven't answered the door yet. They could mail it to you. They could publish it. Alternative service of process is very, very broad, but it is important to get to know you're being sued and to get a copy of what you're being sued for. It's very hard to defend against the lawsuit if you don't know you've been sued or if you don't know what you've been sued for. So having people just not answer the door or avoiding service of process is not ideal. It doesn't really work anymore or in the state of Arizona because we have alternative service. I hear a bunch of pings. Are there any questions on this process? Okay, cool.
No,
So,
we're good.
All right, perfect. On the defendant side, when you get served, you've got a time limit on on how long you have to file an answer. And an answer is saying, I got the complaint, I agree with 1, 2, 3, 4, I deny 5, 6, 7, 8, whatever. You can admit, deny, or you don't have enough information to respond. But you do have to respond to every single allegation in the complaint. Sometimes people will just say, I admit all of it, but here are my defenses. Well, when you admit everything in a complaint, you just said, there's nothing in dispute, so go ahead and get a judgment against me. You can't do that. You have to deny some of the allegations, and you have to have a good faith basis for denying allegations in a complaint. You can't just deny it all, especially if it's, we're suing, Jane Doe. Well, if your name's Jane Doe, you can't claim that that's wrong. So it's really important to, when you're filing an answer, that you're actually doing it properly and doing an admit or deny accordingly. And the template answers, I've also provided copies in the materials from Superior Court and Justice Court, can be a bit of a trap because there are some, I admit this, I deny this, but you really have to take a moment and think whether or not you should admit to something. Like, for instance, when I get a complaint, it's like one of the allegations will say, well, the debt collector sent numerous letters and defendant just never responded or, made an attempt to pay the debt. Well, I'm going to deny that because you didn't send my client a letter. You got the debt a month ago and then you filed lawsuit. So I'm going to deny that because that's ridiculous. You didn't even give us an opportunity to resolve this without litigation. So sometimes it's like the amount of that I'm stating, let's call it random number, $3,500 is true and accurate, and but there's no copy of a statement or credit card bill or something like that. So I'm going to deny that. So you really have to take a minute when people are filling out these admit denies to really just take a moment and think it through. Like, should I admit this? Is this accurate? Is every word in this sentence correct? Because if it's not, then you should deny. But then there's always, of course, I don't have enough information to really know whether or not I should admit or deny this. And that's usually based on like a company not properly identifying a debt. Like if they say it's a Capital One card for X amount of dollars and your client's like, I don't know, I don't remember having a Capital One account, or I had 15 accounts, but there's no account number, there's no last four, there's no information to really give them any guidance on what they're being sued about, and there's no exhibits attached. Well, you may not have enough information to actually, admit or deny anything. So do the best you can on that. The second way to go is a motion to dismiss. Motions to dismiss are usually filed before you file an answer. And those are complicated. I wouldn't try that as a layperson. I mean, that is attorney territory, because a motion to dismiss is usually under 12b-6, which is failure to state a claim, which you most commonly see in these debt collection lawsuits when there is a statute of limitations argument or the wrong party is being sued. So you see it when husband and wife get divorced and the debt collector is only suing one of the parties, but it wasn't their credit card account. They were only an authorized user. Or again, the statute of limitations. There are some other weird reasons why I've filed a motion to dismiss, but they're pretty few and far between. Usually the best way to go is to file an answer. And on all of the template forms, they do give you the option to say failure to state a claim. So, but usually you're only going to use that when there's a statute of limitations argument, or it's the wrong person, they're suing the wrong person, or or you've already paid the debt or something like that. It's weird. But after you've kind of gotten through this part, what comes next is usually a scheduling conference. So the court will send out a notice saying you've got a scheduling conference on such and such date. And I'm not going to lie, the courts aren't the best at actually getting those notices to the parties. So if someone is involved in litigation, it is really important to check the court docket. It is available online for free through the Justice Court or the Superior Court, and you can search by the case number, just to make sure that you're aware of all of the hearings that are coming up, because it'll show on there that there's a hearing on this date at such and such time, and then you can call the court and get instructions, call the court, have them update the mailing address, or just say, hey, I didn't get a copy, can you fax it to me, email it to me, whatever. But it's really important that you don't miss the scheduling conference, because if you do, the defendant could actually end up getting a default judgment. I've seen it happen where people just don't show for these mandatory hearings, and then the court has no choice but to enter a default because one of the parties isn't participating in the process. Same with the plaintiff. If the plaintiff doesn't show up, the court may dismiss the case because these are mandatory hearings. They are not optional. The good news is about one good thing that's kind of come out of the last year is 99% of these hearings now are telephonic. So there's no reason to file a motion for a telephonic hearing. It's already telephonic. And the court has really streamlined that process. They have their own special phone number, their own special code. So you do have to have those instructions in order to attend the scheduling conference. So if you don't have it, in advance, you want to call the court about 30 minutes beforehand, because they do have long hold times, to make sure you hit the conference on time. Can't miss those. Very important. But once you kind of get past the initial preliminaries, you get into the nitty-gritty, which is the discovery process. Discovery is the most important part of litigation. It includes a lot, like your initial disclosures. For a plaintiff, they're going to say why they're suing you, why they think they're going to win, how much you owe them, what they're seeking in damages, whether or not they have any witnesses, whether or not they have any experts, whether or not they think there's insurance claims involved. Like, there's a lot of information in the initial disclosures that are really important for the defendant to look at. And the defendant has to disclose as well. Obviously, you don't have as much to disclose as a defendant in a debt collection lawsuit, but there is stuff you have to disclose, like who your witnesses are, usually just the debtor, and maybe somebody else who has pertinent information like a spouse or an employer or something like that if you're doing a counterclaim. And then you have requests for production. So that's where you're saying, hey, I need a copy of blah. And there are standard forms for these. There's templates that you can find on the internet about them, but you're limited to how many times you can request documentation from somebody. Requests for admissions. These are tricky little suckers because you have a certain amount of time to respond when you get a request for admission. And if the plaintiff will always send you something like, I admit that I owe the debt. I admit that I owe X amount of dollars. I admit that I was served, I received multiple copies or multiple demands for this debt. I admit that I failed to make payment. I admit that I have, refused to cooperate with the process. Like, you'll see some pretty crazy stuff in a request for admission. And if you don't respond by the given deadline, all of that is deemed admitted. And now, you can't contest it later. So if you get a request for admission, you can't ignore it. You have to actually look at it, review it, respond, admit, deny again, and move on. Usually they're limited to a couple, less than a couple dozen requests for admission. Sometimes you'll see some that are only 2 or 3 pages long, but you do want to check and make sure that they weren't actually sent out. I've had a few law firms that say they sent me requests for admissions. I, of course, never got them. And so we got into a battle and, ultimately determined that they just weren't mailed out. So then I get them and then I fill them out and return them. So you do have to kind of stay on plaintiff's counsel for discovery, making sure that your client or whoever you're helping is actually getting through this and getting the documentation that's supposed to be coming to them, because there are serious consequences for not participating in this process. Interrogatories are detailed questions. So those are where your compound questions come in. Let's say it's Bank of America, that's the plaintiff, and you're like, okay, I want to know, who's responsible for sending, who signed this bill of sale off to so-and-so, who transferred this debt to the next debt collector. I want to know their name and their contact info or something like that. You're probably not going to get a response, but those are the types of questions that you can ask in an interrogatory for more detailed information so you can figure out whether or not this is a valid lawsuit. Depositions is Q&A, right? Q&A under oath. No one really likes to be deposed. It's a pretty terrifying thing, I find, for all of my clients, but it does happen quite frequently in high dollar debt collection cases. But at that point, the person really does just need an attorney if you're being sued for more than a couple $100,000. Affidavits are usually helpful, especially on the defense side where there isn't a deposition and the defendant is saying that there was some misconduct by the plaintiff, like they kept contacting me at work, they never attempted to collect this debt, this isn't my debt, whatever you want to say in an affidavit, so long as it's true, because it is under oath and you are subject to perjury. Affidavits are very helpful pieces of evidence when you don't have a whole lot of discovery going on and you just need to get some stuff on the record. And then subpoenas, you can request subpoenas from the court to get information from other parties about certain types of debt. So like a bank, to prove that you paid something, or to get old account statements from somebody, something like that is usually when you would use a subpoena. Super rare that you're going to go through this whole process in a debt collection case, but this is really the highlights of what discovery looks like. Once you're almost through with discovery and those deadlines are set in your scheduling conference, there will be a settlement conference. And usually there is a deadline to have good faith settlement talks. And all that means is that the parties have met and conferred about negotiating a resolution. And this is really where you want to get rid of this case. By the time you're into discovery, you should already know whether or not you're going to win. And the odds are you're going to lose. So you really want to make sure that you take the opportunity to try to negotiate a resolution with the opposing parties. And a quick note on settlement ranges. There used to be a time where you could settle for pennies on the dollar, where you could settle a debt for 10%, for 20%, for 30%. That is not the case anymore. If you are in litigation and your client has been sued, or you've been sued, whatever the case is, you are looking at best case scenario, 40%. Worst case scenario, 100%. A typical range these days, and what's safe to set an expectation for somebody, is about 60%, because that is kind of the industry standard right now. It covers, they did pay an attorney to to file this lawsuit. They've wasted some time in this court, and so they are going to want some more money. They're not really going to be inclined to take less than 60%. So if you get a 40% offer, take it and run, be super happy, and move on. Obviously, if your client doesn't owe the debt, if it's not theirs, then you should continue down this process. But if it is their debt, they owe it, and they can afford a settlement, you should take a settlement. Now, a lot of times, debt collectors will also agree to a payment plan. So even though they're taking a 60% reduction, they'll also agree to payment terms, usually 12 months, but in some cases, you can get them to stretch that out to 24 months. Obviously, it depends on the person's financial position, but just so you know, if you're thinking, I'm going to fight this lawsuit and I'm going to get a 10% settlement, that's just not going to happen. You're really looking at some big numbers. Obviously, the bigger the lawsuit, the scarier that number is. If someone's being sued for $10,000 and they want to settle for $6,000, the person may not, just flat out may not have the money. And especially if it's like a repo case, but we'll get to that a little bit later. So once you get through the settlement conference, let's say they're still not willing to negotiate any kind of reasonable term, you may want to just go ahead and do arbitration. Arbitration only happens in superior court, and arbitration has its own process. I tend to arbitrate. In Arizona, the arbitrators are attorneys who have been licensed to practice for more than 5 years, who are in good standing. And you can be up for arbitration every 6 months. So every 6 months, I am arbitrating a case. And they tend to just be car accident cases for whatever reason. But the arbitration is just by a third-party lawyer who's looking at both people's sides and making a decision based on the facts of who should win and how much they should win by. So arbitration is helpful because they are going to, encourage the parties to facilitate some kind of resolution. But that's the end, usually, of the case. If it is arbitration, that's where it ends, unless people want to appeal the decision. So you can, if you don't do arbitration and settlement conference doesn't go well, you're moving into motions. And sometimes people will jump the gun and file a motion for summary judgment before a settlement conference or arbitration. But a motion for summary judgment just means there's no more facts in dispute, this is owed, and we should win. And that can either be for the plaintiff or the defendant. Either side can file a motion for summary judgment. They may both file cross motions for summary judgment. If that happens, both sides have to respond to the motion. If a motion happens, a response is required. If you don't respond, then the motion will be granted. You have to respond to a motion. All motions need a response, even if it's silly. So you have to respond to all of them all the time. But usually a case, especially a debt collection case, if they're filing a motion for summary judgment, defending against it on the defendant's side is an uphill battle, and very likely you won't win. So it's important to review it and see what defenses there are, but motion practice is a totally different discussion. But if there are no motions for summary judgment, then you go to trial. And once you go to trial, those hearings tend to be a couple of hours, sometimes only 60 minutes. But after the trial, there is a final judgment, and they can enter a final judgment usually 60 days after the trial. I had a case where it was a summary judgment hearing last April, and there's still no final judgment entered. Just FYI, it happens. But that'll take us to our first break. That was a lot of fun on the litigation stuff. But if you've got questions, I'll be sticking around. You can always email me. But
okay, and before we take that break, or while taking that break, I'm going to go ahead and broadcast the first verification word. So I'm going to put that spotlight back on me for a second. Excuse me. Okay. Rochelle, can you see what I'm holding up?
No.
No? Oh, that's because my camera's off.
Yes.
Okay. All right. So the first verification word of the day is tire. So like the tire on a car, T-I-R-E. And so you want to write that word down and save that. As I mentioned at the beginning, there'll be 3 verification words that you'll need to email me when the webinar is done in order to get your certificate of completion. All right, and then so that's the that's the first word, and then we'll go ahead and take a quick 3 or 4 or 5 minute break, and then we'll come back and finish up with Rochelle.
Ha.
And John, by the way, we're speaking out there, and we need an overnight.
All right. Is everybody back?
I think so. I think we're ready to go.
All right. Welcome back. So moving on to part 4, the most common types of debt collection lawsuits. And back to that. So the most common, hands down, is going to be credit card debt. There are just a ton of credit card debt lawsuits filed. In Maricopa County, it is tens of thousands of lawsuits are filed in these debt collection cases. And only 10% of them are of the defendants are represented by counsel. So there's like 90% of these people who could use some guidance on how to deal with being sued by a debt collector. There's a huge need for it. And the most obvious people to fill this position is going to be certified legal document preparers. The courts will get there because people need representation in these types of cases, period. So in dealing with credit card cases, people are suing saying it's stated contract, whatever or it's a breach of contract, whatever it is. Credit cards are probably 9 times out of 10 the case that you're gonna see someone come to you needing help with. The second is going to be vehicle repossessions. Once a car has been repossessed, there is a notice that goes out saying, hey, you owe us X amount of dollars, or we're going to sell your car at auction. And then hey, we're going to sell your car at auction on this date. And then, hey, we sold your car at auction on this date. Hey, you owe us X amount of dollars because you owed us X amount, we sold it for Y amount, and you owe us Z. So the problem with these vehicle repossession cases is, the deficiency balance is substantial. It is not uncommon to see a lawsuit for $20,000 on a vehicle repossession case where someone bought a car for $25,000, made payments for a couple of years, defaulted, they got sued for $20,000 because they only sold the car for $1,000. And that can happen when someone trades in a car but still owed a lot of money on it. So if you had, I don't know, some kind of Honda. We'll pick on Honda. You had a Honda. It wasn't really working well. You still owe $10,000 on the car. It was only worth, $4,000 or $5,000. You traded it in. They paid off your other car. Well, you just included negative equity into your new loan for about $6,000. Well, when a couple years goes by on this new car and they then sell that car at auction, you could easily owe $15,000-$20,000. And I see it, and it's really, really crappy because people couldn't afford the car payment and the company wants all this money on this car loan. The biggest issue that I see that people get really upset about is what the dealership sold the car for at auction. So seeing them sell, I saw a car sold once for $375. And the person ended up owing, they were suing them for like $12,000. So it's outrageous what's happening in these vehicle repossession cases. You can see a 2018 car sold for $1,500. It has to be a commercially reasonable sale. There are statutes on this. Getting documentation from the creditor is really important. Sometimes they don't communicate to the law firm representing them that what they actually sold the car for or what the issue was. Sometimes the paperwork's wrong. Sometimes they didn't do notice. There are a lot of things that happen in these vehicle repossession cases that's worth taking a look at. But definitely can't allow that to just go to a default judgment. If someone doesn't even file an answer on it, they will get a judgment against them for the full amount of the deficiency balance, plus attorney's fees, which will be around $3,500, plus post-judgment interest, probably at 18%. So whatever that judgment ends up being, if you fast forward a couple of years, it could very easily be $40,000, $50,000. And that's a huge burden that's not going to go anywhere for a decade. And then a decade later, it'll keep them from buying a house. It'll keep them from being able to refinance a house. It'll keep them from even wanting to sell their house and get into a new place because this judgment will have to be satisfied, most likely. The other most common type of case that people get sued for is private student loans. National Collegiate Trust is a huge third-party servicer of private student loan debt in Arizona. And there are others, like if someone took out a loan from ASU that was a private loan that just didn't get paid because something happened with their paperwork, they probably won't get sued, but they still need to resolve it with whatever college it is. But if they do get sued, it is important to take a look at who's suing them, what was it for, is the school still around? Just take a look at the paperwork and see what's going on, because some of these private student loans, can be upwards of $50,000, $100,000. It's really important to not just let that go to default. Some of those terms some of the consequences can just be mitigated simply by filing an answer and forcing someone to look at the paperwork. One of the things I see on the rise, which is pretty terrifying, is medical debt lawsuits. Most companies don't sue for medical debt, even today. But in some states, like our neighbor New Mexico, they are seeing a tidal wave of medical debt collectors. Right now, there aren't any law firms in Arizona handling medical debt collection. There is one, but they mostly only do expired debt. So be careful, because we're going to start to see more medical debt collection coming from law firms. It's inevitable. It is only a matter of time. And those medical bills, it used to be 5-10 years ago, if you got an ambulance to go to the hospital, it might be $300 or $400, but now it's $1,500. A trip to the ER may have only been $2,000, and now it's $10,000. So those bills will start to be sued on. It's inevitable, and just be aware that it's already starting to happen. I have started to see some medical debt collection lawsuits, but they were also coupled with pretty egregious Fair Debt Collection Practices Act violations. So on those cases, I did file counterclaims. It did mitigate my client's liability, but we'll get to that in a minute. The next big type is going to be apartment debt for post-move-out damages. It also happens on, single-family resident rentals as well. So a post-move-out damage charge is when there is property damage after the person moved out. So you may have paid all of the rent, but if you had a dog, they'll say, oh, well, there's pet smell, there's pet odor, we had to replace all the carpet. So you owe us for carpet replacement. You were a smoker, so you owe us for having to repaint the unit and for having to clean out all the vents, whatever. So you can have some pretty big post-move-out damage bills. I've seen some for $20-something thousand that people have been sued on, and you have to fight that. You cannot just let that go, because those are usually questionable at best. It's worth fighting on those cases, because those bills can be outrageous. And then, of course, title loans. Speedy Cash is probably the big one in Arizona that I see that sues people. And those interest rates are huge. If you let it go to default judgment, you're looking at 399%. And when it goes to default judgment, the judge just gets a stack of these things. So if someone doesn't file an answer, then the plaintiff files an application for default. And then the defendant gets another, usually 10 days to respond after receiving that paperwork. But the problem there is, if no one responds, the judge just has stacks of paperwork that they need to review and sign off on. And unfortunately, because there are thousands and thousands and thousands of debt collection lawsuits every single year, they're not reviewing it individually. They're not taking a look at what people are seeking in attorney's fees. They're not taking a look at what interest rate is being applied to the lawsuit or to the default. They're not paying attention to how much prejudgment interest is being awarded. All they're doing is saying, well, no one responded, this looks reasonable, kind of, and then they approve it. It's not necessarily their fault, but it is a huge problem. So don't just let people get default judgments on things, because the consequences are way too great to allow that to keep happening. And then any other kind of contract debt. There are mostly just contracts. There's a ton of miscellaneous stuff out there that people get sued for all the time that counts as a debt collection lawsuit. So what do all of these cases have in common? Well, the cause of action. It's all breach of contract, all subject to a 6-year SOL, with exception, of course, to the vehicle. That one's only 4. Or medical, which could be 3. That's why it's important to always, 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 in any litigation, make sure there's a contract, make sure you get a copy. That's like your big ticket to get out of a lawsuit is, do you have proof my client owes this debt? Make them prove it. In many, 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 many cases, I'm embarrassed to say, opposing counsel doesn't have a contract. They don't have any proof that the debt's owed. They just filed the lawsuit. So you can get cases dismissed simply because there is a lack of evidence. So always push it. Don't just let people file an answer and then not follow up on discovery and getting the documentation. Because if there is no proof, there is no case. We're in court now. It's a court of facts and law, not equity. So justice doesn't really happen here. It's just proving your case. The other common causes of actions that you may see in addition to breach of contract is going to be a stated contract or unjust enrichment. There are others, but those are really like the top 3 that you're going to see in a debt collection case, cause of action filed by the plaintiff.
Rochelle?
Yes.
I think there's at least one question.
Yes.
Rob Merrill has a question. Rob, if you want to unmute.
Yeah, hi, Rochelle.
Hello.
So I guess my question is, I've heard these horror stories. You get clients who come in every now. We don't do any civil litigation, but we'll kind of give people some, I think there's some, instruction or some options. But we hear these stories all the time where they say, well, they couldn't provide the contract, but the judge just let it go through anyway. Is that typical when you have representation, or what's generally the court's action on those types of things where they can't produce a contract?
The court definitely shouldn't be rubber stamping something without a contract. I mean, it depends on the type of case. So if it's a credit card case and you're like, I want a copy of the contract, but there's the copies of, the bill statements, that match the client's name and their address, well, the court's going to let that go because, there was an implied contract because there was an account statement showing that, they were making monthly payments on a credit card. If it's a medical bill, that probably isn't going to fly. There has to be a contract unless they're saying it's unjust enrichment and they're going to allow it. If it's a vehicle loan, there has to be a contract. Student loan, there has to be a contract. Like most of these cases require a contract. The only exception I think would definitely be the credit card case, mostly because people will claim like there was no contract when, there's all these account statements. So that's probably the only instance I would see a judge allowing that. But oh my gosh, any of these other instances where there is no contract, that would just be outrageous.
Thank you.
Appeal. Good question. Oh, let's also talk about this other issue that brings up a good question on, does it have to be the original contract? A lot of people think that that's a defense, well, we need one that I actually signed. Well, we're in the age of digital contracts, so electronic signatures are totally acceptable these days. So if it's just a copy or it was an application that was completed online, that's fine. I think we're obviously going to see a lot of problems with that with Carvana and the online retailers now for vehicles that will eventually get repossessed at some point in the future. I haven't seen any of those lawsuits, but that'll get litigated in Arizona in the next couple of years as well. But the standard of evidence on proving someone owes a debt is not that high in Arizona. In other states, it's more rigorous, but not here, not for debt collection. We're pretty debtor friendly in Arizona, just FYI, just so you know. This is already an uphill battle simply because your client got sued. The common defenses that I see that people definitely make the mistake of doing, this is the number one way to get a judgment against you, even though you filed an answer, is I owe it, but I can't afford to pay it. The creditor wouldn't settle with me. The settlement agreement was not affordable. I want to talk to the judge. None of these are defenses. These are all admissions. This is saying I owe the creditor. And that's the end of the analysis. Like, you just admitted that you owe the debt and that there's nothing in controversy. And because nothing's in dispute, they can get a judgment on the pleadings just based on the answer that was filed. And I see it happen a lot. People can't just say, I owe it, but that's not a defense. You don't even want to say, I owe it. Like, you can't admit that you actually owe the amount that they are seeking. You have to put up some kind of defense and allow it to be litigated. So if your client is tempted to say, but I think I do owe it, well, then they should pay it. You can't really help if they are adamant that they owe it, but they just want to settle. Wanting to settle the debt is can happen through the litigation process, but it's not a defense to being sued. Just because the creditor offered, well, we'll give you payments on the full balance, but the payments are going to be $900 a month. I mean, that's not a defense either. Like, you still owe the debt. Like, you're still admitting that you owe the debt. So you can't say in an answer, I owe it, but that's just not a defense. And it's really unfortunate because I know that people want to be honest and they want to, do the right thing. But when you say that in a pleading on a record in court, you just committed the biggest boo-boo, because you just said this lawsuit's valid. Every aspect of it is valid. I'm not disputing any of it. And they will get a judgment against the client within, a couple of days. It's a big deal.
Rochelle,
Yes.
I have a question. This is Don. When I was doing this type of work years ago, I would often have people come in and want to raise as some kind of defense the fact that they had entered into some type of a payment arrangement with the creditor that they had kept, but the creditor went ahead and sued them anyway because they were in default on the original debt. Is that, I don't know how common that is to raise nowadays, but is that a legitimate defense?
Yes, it is. We will get to it. That is an actual defense. Yeah, they can't sue you. I usually get cases dismissed, but I'll talk about that way more detail in a second.
Okay.
The second most common defense that I see that's a no-go is Fair Debt Collection Practices Act violations. I owe it, but the debt collector violated the FDCPA. This is also will result in a judgment if you say that as your primary defense, because you're still admitting that you owe the debt and that there is no issue in controversy, and they will get a judgment on the pleadings if a client writes that. FDCPA violations are broad, and it's a very low standard. They are not hard to win on. In a counterclaim, this is not a defense. It is a counterclaim. It's what you're saying. I don't think I owe this. Here's X, Y, and Z, but I am also suing the plaintiff for violations of the FDCPA because they did X, Y, and Z. One case I had was involving a medical bill where the debt collector contacted the defendant at their place of work repeatedly, even though they were told that they weren't allowed to do that. And they were demanding more money than what was stated on the medical bill. A lot more, like 4 times as much. And you can't do that. If you're going to say someone owes you money as a debt collector, you have to be exact and you have to be accurate. There is no defense to not doing it correctly. So when they sued her for this medical bill, we counterclaimed for FDCPA violations. And because of how it worked out, the FDCPA violations with attorney's fees were more than the amount that they sued her for. So they actually had to write her a check on the case because they lost. They did win that there was unjust enrichment and she did owe them money, but she was the net winner because they owed her more money for the Fair Debt Collection Practices Act violations and attorney's fees. So the FDCPA is not a defense. It is a counterclaim. And you can raise it. It's sometimes a good one, especially when there is misconduct by the debt collector. But it's you have to have a reasonable good faith basis to raise a counterclaim. You can't just do it because you want to. I mean, if you've got a client that's, complaining about what the debt collector has been doing, like they called my mom, they contacted my grandma, they served my dad, they emailed my brother, like those are all questionable conduct that should definitely be complained about in a counterclaim. They said I owed them 15 grand, but the bill only says it's 3. They're charging me interest. Those are things to really just kind of take a look at and maybe get an attorney opinion on to see if you've got a claim for FDCPA violations. But remember, it's a counterclaim, not a defense. And it's unfortunate when I see people, in my office who have gotten judgments because they really did have claims for Fair Debt Collection Practices Act violations, but they didn't raise them properly, so the court didn't have an opportunity to actually adjudicate. So it's really important to remember FDCPA. Not a defense. It's a counterclaim.
Rochelle,
Yes.
There's another question, if you would. Okay.
Yes.
Susan is asking if the client is an LLC and never signed guarantee, and a spouse is not a member of the LLC, but still gets a judgment and then serves the spouse, how is that?
Well, that's a mess. In those kinds of cases, LLC.
And if I didn't.
I'm sorry, can you say that last part?
What's that, Rochelle?
I missed the last part of what you said after spouse is not part of the LLC, but was served.
Okay.
Let me just repeat the question to make sure I understand it. There was an LLC that was sued, but they served the spouse of the owner of the LLC, and she was not a member, and the owner didn't sign a personal guarantee.
That's what I understand the question to be.
Okay. Yeah, that's a messy case that's definitely needs to be defended against because an LLC literally means limited liability company. So the only way to file suit is to file suit against the LLC. You can't include the owner of the LLC as a named party in the complaint. So it would be ABC LLC. And in some cases where you're also suing the owner, it would be ABC LLC and John Doe member, whatever the case may be. In Arizona, they may also include John Doe and Jane Doe because it's a community property state. And so they're just trying to attach the owner's community property share in the lawsuit. I know, I don't like it. We've got to clean that up in Arizona, but it's right now, that's how the law stands. In a case where there is no personal guarantee, the only party they can sue is the LLC, and they need to serve the LLC at the statutory address. So if the statutory address or the address that they have listed on the Arizona Corporation Commission's website is the home address where the wife lives, well, that might be proper service. Might. If the parties are divorced and the wife doesn't know where, the ex-husband lives, then she can reject service and say, tell the debt collector in writing or whoever sued her and served her, I received this lawsuit in error. I am not a party and I don't know where they are. It's still a problem because, you need to update your address with the Corporation Commission, but it can be pretty tricky when you're dealing with that many people. Now, they can't actually sue the wife unless, she was, like I said, if they were as a personal guarantee that was signed. Also note, anything after like 2018, 2016, there probably is a personal guarantee included in the contract. I've seen them pop up, but always worth exploring. Get paperwork. I don't know. Does that answer your question?
I think it did. Yes.
Okay. Good. Good question. Complicated question. But yes, weird. So this is a copy of the sample answer, template answer that you can file in court. And they give you all of these boxes in Superior Court that you could check. And so I just wanted to go through these defenses and then additional defenses that you may have in a debt collection lawsuit. So one thing you should not do is check all of the boxes. When someone checks all of the boxes, when you do your initial disclosures and right before you go through an arbitration or a settlement conference, you actually have to have enough facts to justify all of your defenses. Alleging defenses is very time consuming and difficult to prove because you have to prove every single defense that you check. So if it's not really a good defense, you don't even want to raise it because you're making your life a lot harder. Yes, you're also making the plaintiff's life harder, but you're the one with the burden of proof on the defense. So do not check all of the boxes because not all of the boxes even apply. So the first couple, lack of personal jurisdiction, just means you can't be sued for this debt. Like in the case of that we just talked about with the LLC, where, let's say the wife got sued, but there was no personal guarantee. She could file an answer saying, I deny all of this, plus lack of personal jurisdiction. This isn't my debt. Great example. Lack of subject matter jurisdiction would usually be something like a contract that you can't sue for. I see some occasionally for sex services. That's not a legal contract in Arizona. You can, like, you just can't sue for that. You can't sue for debt that's past the statute of limitations. So, you know, if you suspect a debt is SOL, you may also want to check lack of subject matter jurisdiction. Those are the only main examples I've seen recently is usually if it's subject matter, you know, it's because it's a contract that's not legally valid or, you know, it's SOL. Insufficient service of process is kind of a funky one. You can raise it, but because you have actual notice of the lawsuit, it's probably not going to fly if you're filing an answer. So insufficient service would be a good one to raise if someone was in Texas and got served and found out about the lawsuit. I mean, in that case, you would check lack of personal jurisdiction, lack of insufficient service of process, because they're suing you in the wrong court. The fourth one is failure to state a claim upon which relief can be granted. This is a 12b6. It's basically saying you sued me for something that you can't sue me for. Usually the only way you're going to check this is if you've really got a good statute of limitations argument or identity theft argument or fraud argument. That's really the only cases that you're gonna need failure to state a claim upon which relief can be granted, which just means, like, even if this was a claim, the court couldn't help you. Even though I might owe you money, there's nothing the court can do to help you out. So is another way of thinking about it. Accord in satisfaction means the debt was paid. The debt's already been paid. I don't know why you're suing me. Or we have a settlement agreement and I completed the settlement agreement and I don't understand why you're suing me. That's accord in satisfaction. Always, always, always worth asking the client if they had previously paid the debt. Sometimes they do get sued, but sometimes they've paid the wrong party. I had a case recently where a guy entered into a settlement agreement with a third-party debt collector. He got a settlement letter in writing, he paid the debt, he got a paid in full letter, and then he got sued by a debt collection law firm for the same debt. And we're like, how on earth could this happen? Well, the debt collection company that he paid, in their records had screwed up who was collecting the debt, and they hadn't actually released it from their system. They didn't own the debt anymore, and they had just collected his money in error. So they had to refund him his money, and then that same guy had to then settle with the debt collection law firm. But obviously, one of the defenses that he raised was accord and satisfaction, and through the discovery process was able to determine that he just paid the wrong party. So it sucks when that happens, but it's definitely worth making sure that people are paying the right people, which is why you always want a contract and why you need proof that whoever is suing you actually has authority to sue you, because they sometimes mess that up. Arbitration and award just means that it's been to arbitration and it's already been litigated. Like, we shouldn't be in court again. Assumption of the risk doesn't even apply in this kind of case. Assumption of the risk is a tort game. Like, really, like if you're on, I guess the classic example is, I don't know how to ride a motorcycle, and I want to take your motorcycle for a test drive, and I crashed it and injured myself. Well, one of the defenses, obviously, on the plaintiff's, or the defense is going to say, well, he assumed the risk by taking the motorcycle out for a test drive. So not applicable here. This box should never be checked in a case like this. I see some people try to argue that, well, they knew I had bad credit, so they assumed the risk. Not going to fly. Don't make your life harder. Contributory negligence, again, is a tort defense. It's saying, yeah, I injured you, but not that much. Duress is a defense that you would use, like, they made me sign the contract. Probably not going to fly in this case. I would avoid checking that box. It's really hard to prove. Estoppel just means they are stopped from collecting the debt for whatever legal reason. Usually that's not applicable here. I wouldn't check that box. Failure of consideration means that you agreed to terms without getting any benefit out of the bargain. If it's a credit card, not going to fly. Car loan, you got a car. Student loan, you got a student loan. Like, you're not really going to win on a consideration argument. Fraud is a good one. Depending on the case, it's really difficult to prove fraud. There are a lot of elements to proving fraud. Fraud would be that they just straight up misrepresented the terms of the contract and fraudulently induced you to enter into the agreement. If you have a claim for that, great. If you don't allege it. Illegality means the contract's illegal, like most commonly a contract for sexual services, right? Can't sue for that. Latches. I love latches arguments, but I have never won on a latches argument. Latches just means that it's been so long that they shouldn't be allowed to sue you out of equity. But in Arizona, we have statute of limitations, so you're probably not going to win on the latches argument, so you shouldn't even check the box. Judges just don't like latches. I don't know why. They just don't like the argument. License, not applicable here. Payment, this is the question Dawn raised. Like, I've already paid this. Like, I shouldn't be sued because I am paying it. So that's definitely the defense you want to raise, is going to be, I'm in an agreement already. We've already agreed to settle this. So this happens when a lot, actually, where someone finally negotiates a settlement with a creditor. They enter into a payment agreement. They've been paying for X amount of time, and then the debt collector files suit and has them served. It's a pretty big deal for the debt collector law firm to do that. Like, they should know that they shouldn't have proceeded with that case. So usually I just, take the stance, I need you to voluntarily dismiss your lawsuit because we are already in a payment agreement, and I'm not going to litigate this thing because you screwed up. So in many, many, many cases, the debt collector will just agree to voluntarily dismiss the case and proceed with the settlement as it is, no issue. In some cases, the debt collector will say, fine, but I don't want to dismiss my case. How about your client agree to a stipulated judgment, and then we just won't execute it, and we'll satisfy the judgment when the payment plan's completed. And sometimes you don't really have a choice but to accept those terms. But we'll get more into those potential outcomes and what they really mean later on in probably about 10 minutes.
Rochelle,
Yes.
I have another question from Rob Merrill. Go ahead, Rob.
So 2 questions, actually. This kind of goes back to another point earlier, but I just thought of it. Are LLCs required to be represented by attorneys? I had heard a rule that the members cannot actually represent an LLC in court. That's question number 1. Question number 2 is, if there is an improper lawsuit like you were just talking about, is it possible to collect, the defense, attorney's fees and court costs in that case?
Yes. So LLC representation by attorneys, it's going to depend on the type of case, like in the type of LLC. Like a corporation always has to be represented by a lawyer. An LLC should always be represented by a lawyer because it's a legal entity. It is not a person. So there are some exceptions in justice court for a non-attorney or a member or not a member, but a representative of an LLC to bring forth the lawsuit. But in Superior Court, it does need to be a lawyer. You can get cases dismissed for the party not having legal counsel, bring the lawsuit. But it's going to depend on the court, and it's going to depend on the judge. Like sometimes, even though the rule says, sometimes that just doesn't work out. I have no idea why that is. I am not a judge. But yeah, you're right. Like a LLC does need to be represented by legal counsel, but not necessarily in justice court. For attorney's fees, if you are the prevailing party in a contract case, you are entitled to reasonable costs and attorney's fees. So if you're defending a case and, the attorney successfully gets the case dismissed, then, they can file an affidavit and say, hey, I'm entitled to attorney's fees because I was the winner of this case. That does happen. So, especially in a contract case, like the winner is entitled to attorney's fees. Does that answer your question?
Yeah, it does. Thank you.
Perfect. So the release option here just means that they have already agreed to release you of liability. Like you have like a paid in full letter or some other document saying that it's already been paid. It's rare, so that's why I didn't really check it. Most people don't have that. Res judicata is just a fun one. It means it's already been litigated. Like you've already sued me for this. Why are you suing me again? Like there's already a judgment. I circle it because it freaking happens. So sometimes res judicata is a good defense. Statute of frauds usually just means that it's a contract that had to have been in writing. It's really only valid in real estate transactions. It's very rare, or for contracts more than like $1,000, but it's super rare that it would actually be a viable defense in debt collection cases. And then of course, statute of limitations, which we covered. Waiver means they waived their right to sue you. Probably not. And other defenses listed and explained below. So when you're filing a debt collection lawsuit answer and you get to put up all these defenses, don't check all of the boxes. These are the boxes that might be options for you to check. But you don't need to check them all. You only want to check the ones that give you the best possible case to defend and the best possible options of, slowing down losing or actually winning, depending on how egregious the case is. Other defenses that I like to raise are failure to comply with notice requirements. So every contract probably has some kind of notice requirement, like when things are in default, when the case should be accelerated, like I can sue you and claim the full amount due is now owed. This is really important, specifically in like the car cases and the student loan cases. They have to comply with their own notice requirements. If they're going to sue you on a contract, they actually have to comply. So if they didn't say that they were going, if you never got notice that they were going to repossess your car, I mean, that's kind of a big deal. If you never got notice that they were going to sell your car, that's a big deal. Those are issues that you should raise. They may not be complete defenses to liability, but they do mitigate the person's like liability for having to pay this debt. So it's always worth making a note and just making sure everything, all the, I's were dotted, T's were crossed. The second one I like looking at is improper interest calculation. This one's tricky because everyone calculates interest however they want, and it becomes mathematically complicated very fast. So if you're going to argue that someone didn't calculate interest right, you're going to probably need an expert witness to do it. Attorneys are notoriously bad at math, which means judges aren't the best at it. So you need someone to come in, explain why the interest calculations are wrong. And in Arizona, it can be a pretty big deal to misstate how much interest is due. You run afoul of the anti-usury law. We don't have usury laws. We don't have a cap on how much interest you can charge, but we do not allow people to charge more than what is legally owed. Otherwise, they have to forfeit all pre and post judgment interest. So making sure, just remember interest, especially not necessarily on credit cards. You're probably not going to win on those, but any other contract where there is interest involved that they're assessing is worth taking a look at and just doing some simple math and seeing if it passes the smell test. Sometimes it doesn't. Failure to mitigate damages is my personal go-to when I don't really have a lot of good defenses, especially when a case has been transferred or a debt's been transferred multiple times. I mean, it's kind of hard for someone to know that it's valid or that they actually owe it when there is a bunch of creditors involved, or they didn't collect it for so long and allowed interest to accrue so high. It's like at some point, maybe the creditor is responsible for their own losses. So failure to mitigate damages is a good one to list with a couple of reasons why. You want to avoid saying, I owe it, but, you don't want to admit to owing the full amount that they're due. You're disputing the amount that's owed. That's the whole point of a failure to mitigate damages argument. And then breach of the covenant of good faith and fair dealing. Both failure to mitigate and breach of covenant of good faith and fair dealing are implied elements of every contract. So every creditor has duty to actually mitigate damages, and every creditor has a duty to act in good faith in negotiating with third parties. So breach of covenant of good faith and fair dealing is a really long way of saying bad faith. And this claim specifically is a defense, but more so a counterclaim. So, the case where you were in a settlement agreement and you were making payments and they sued you, you would want to argue that it's in a payment or accord and satisfaction and waiver, but you would also want to counterclaim on breach of covenant and good faith and fair dealing because they sued you. And you may even have an FDCPA violation because they're telling the court that you owe more than what you legally owe because you're in a settlement agreement for a lesser amount. And so whatever they're claiming you owe in court is a misrepresentation of what's actually due, especially if, the court pleading itself is not evidence, but if they sent a demand letter in advance right before they sued you, the demand letter would be evidence of the FDCPA violation, which is kind of tricky because if it's a law firm, then you're actually suing the law firm for FDCPA violations, not necessarily the debt collector. And law firms are debt collectors, so they may actually be conflicted out of their own case as a result of doing that. So it is a big deal to be in a settlement agreement and have someone sue you anyway. Do I have anybody have anything else that they want to bring up with other potential defenses or things that you're seeing that you have specific questions on?
There is a question from Michael Angel. Mike asks, in many contracts, there's a mandatory arbitration clause, yet a debt collector still will often still file a lawsuit. How do you handle this, as there can be good and bad arbitration? Also, do you use this as the basis for a motion to dismiss?
Yes. if there is like arbitration required in the lawsuit, you can check the box for failure to state a claim upon which relief can be granted, because they should have gone through arbitration. Most of the time, what happens is the court will say, okay, we're not going to dismiss the case, but we're going to basically put it on hold, allow the arbitration to proceed, and then depending on the outcome, you can either file a notice of settlement or dismissal, or we can proceed with litigation. Those are usually the three outcomes. In some cases, the party will be like, especially in a credit card case, they'll be like, well, this is below the threshold amount for compulsory arbitration, and so we don't need to comply with arbitration rules because this is a justice court case. It's a weak argument, but it usually flies. So getting a case dismissed for arbitration clauses is really only a good defense in a superior court case, but usually it won't dispose of the case. It'll simply just be on the court's calendar until the arbitration can be completed. But the court also has its own arbitration process. So they may say, well, we want to use the court's compulsory arbitration and not our third-party arbitration, because the court's arbitration is free. Because again, it's provided by Arizona attorneys who volunteer their time for the process. Does that answer your question? I hope so.
Yes. Sorry, I faded out there for a second. My signal got bad. All right.
All right, good. So possible outcomes. Dismissal is obviously what everybody wants. We want the case to be dismissed. And that just means that the case is over. It was dismissed. There's nothing else for anybody else to do. There were no winners. There were no losers. It was simply dismissed. And dismissed can happen with prejudice or without prejudice. With prejudice means they can't bring it again. Without prejudice means they can sue you again. So even if you get a case dismissed because it was subject to arbitration, it will be a dismissal without prejudice because they could raise it again. Now, if you were already in a payment agreement and your client is still making payments, it again will be dismissed without prejudice, because if your client defaults on the settlement agreement, they could, come back and sue. If the debt's already been paid, obviously it'll be dismissed with prejudice. But that may also end up being a final judgment, but more on that in a second. A default judgment is when one of the parties defaults in the process. Usually a default judgment happens because someone didn't file an answer, or it could happen because the plaintiff didn't show up at one of the mandatory hearings, or that's usually it. Like usually the defendant defaulted on some part of the process by not participating in the process. So we want to avoid default judgment, but sometimes default judgment, especially for someone with no assets who's planning on filing bankruptcy, doesn't really matter all that much. So a stipulated judgment with a covenant not to execute. A stipulated judgment is saying, you know what? I agree. I owe this debt. I owe you attorney's fees. I owe you interest. I owe it all. But I want to pay you less. So I'm going to take a reduction in what I owe with a payment plan for a certain number of whatever. But we'll say to the court, this case has been adjudicated. I agree, I owe it, but I'm going to pay a lesser amount. And the creditor is saying, fine, we will not execute our judgment. So we will not try to garnish your wages. We will not try to levy your assets. We won't record the judgment. That's what covenant not to execute means. So you're saying, I agree, I get a judgment, but I'm agreeing to a lesser amount. And that way, if you end up defaulting on the payment agreement, the creditor already has a judgment for the full amount. Is there a question?
No.
Okay.
Not yet.
And then offer of judgment with a covenant not to execute is a newbie. I started seeing this around 2018 when people were entering into settlement agreements before they were being sued. So there was no lawsuit, nothing had been filed, but what creditors started to want when it was with a law firm was an offer of judgment, which basically said, we're going to do a settlement, but if the debtor defaults on the agreement, you agree to allow us to just enter a judgment against you without actually having to file, follow the process. So we don't have to file a summons and complaint. We don't have to go through the answer. We don't have to go to discovery. No. This is just a judgment. It's not ideal, but usually for someone who, if you're not really negotiating from a position of power, this may be the best option for the client. An arbitration award is when the case has been, there's been an arbitration hearing, everyone, showed up, and the arbitrator will, file with the court the award, who won, how much they won, and the final judgment is when the case has been fully adjudicated and a judgment has been entered. So it's the end of the case. And a judgment, like I said, can be entered for a plaintiff or a defendant, but most likely the plaintiff in a debt collection lawsuit case. That's usually where we're at on those. Those are really the only outcomes in any of these cases. It was either a judgment or it was dismissed, and then there's some other fun stuff, more complicated things. The whole point of these cases, unfortunately, is to help the person lose less. It's rare that people will have an actually good defense to winning one of these cases. So it's really important to keep the end in mind, which is the goal is to dispose of the case. So you may need to just negotiate a settlement. And here are my quick tips on if you're going to negotiate a settlement, these are the goals. This is what a good settlement looks like. One, there is a reduction in the principal balance. So even if the creditor is only willing to take 80%, you still saved this person 20%. If there is 0% interest on payment terms, you were saving that person thousands of dollars in interest. So take the win. You don't want a settlement agreement where they're still charging you 18% interest. They're back in the exact same position they were in when they started this lawsuit. They're better off just continuing to litigate it if they're going to be charging them interest on the payment terms. No prepayment penalties. So if someone is thinking about refinancing their house or something and they want to be able to just pay this in full instead of, using the 24-month payment plan, they shouldn't be dinged for it. Waiving prejudgment interest. We want to make sure that, especially in any case, they're entitled to prejudgment interest. So if it's 18% on a card from 3 years ago, prejudgment interest could have been, $15,000, $20,000. So if they're willing to waive prejudgment interest, you're saving the person thousands of dollars. And then waiving collection costs, court costs, and attorney's fees. And then all of those things, those 4 things, the 0%, the no prepayment penalty, the waiving interest, the waiving collection costs, that makes a settlement agreement that's like normally 80% of the principal balance closer to like a 30% settlement when you add all of this stuff in together. So you're getting the person a pretty darn good deal if you can get the creditor to agree to these terms. And most of them will. It's every single one of my settlement agreements includes all of these. It's just industry standard. You just have to know what to ask for. And then you also, if they're doing a payment plan, agree to a 5-day grace period on late payments. You don't want to have some contract that says if you're 1 day late, you're in default. I mean, especially if the creditor only accepts payment by mail or online, however they do it, life happens. Sometimes the payment date falls on a holiday or a 3-day weekend or whatever. So you just want to make sure you're always including some kind of grace period on the payment terms of the settlement. But these are kind of like the biggies that you really, really want to make sure are included when you negotiate a settlement with a creditor for a client, because this is what saves them the most money. This is what keeps them out of bankruptcy. This is what keeps them from defaulting on the agreement. These are the things that really matter when you're negotiating a settlement for a client. Obviously, there are some other super pro tips, but any reduction in principal balance is a good deal. Like I said, the industry standard right now is about 60% plus all of this other stuff. So people can get favorable outcomes, but obviously if they can't afford it, there's no point in entering into the settlement. Like if it's a $900 a month payment and they make $1,800 a month, I mean, it's just not going to work. And at that point, people are really looking at needing to file for bankruptcy protection if they just can't reach a deal where it's going to be beneficial to them. So just keep that in mind. Like, not all judgments should be settled. Not all lawsuits should be fought. It really is a case-by-case analysis. But if you're going to help people, guide them through the process, just remember what you're signing up for. Like, they've got to go through all of this at some point if you don't settle the case. So if you're going to volunteer to help somebody or charge to help them, which I think will probably be the future of the industry, it is a very lengthy process. And of course, if it's complicated and it's 6 figures, they should probably hire an attorney to help them, because the bigger the stakes, the more there is to lose. But anything other than that, that's it. That's my presentation. Thank you so much. It's been 2 hours and that was a lot. Civil litigation, I know, is kind of boring, so I'm sorry, but all of the materials are here, all of the footnotes, and I'll email Dawn the slideshow so that way you've got a copy of that as well. And of course, if you've got questions, my email is everywhere. I'm happy to answer people's questions, happy to have quick, 15-minute phone chats with people for free. It's not that big of a deal. I'd rather you have the information than guess.
Rochelle, thank you so much. It was a terrific presentation. I just want to encourage people that are attending to encourage the idea that there's a tremendous opportunity out there for certified legal document preparers to offer services to consumers, really on both sides. I know of document preparers, and I have myself when I was doing this type of work. I know of document preparers that are doing small claims and justice court lawsuits for companies that are, usually it's even small claims, but for various types of small claims matters that you identified. And then on the other side, helping consumers with the answers to these types of litigations. Great opportunity for people to be involved. But have cases that, if people have cases that are not first to handle, what's a good referral for you?
Yeah, so I deal primarily with business litigation. So if people have, complex business litigation cases or just high dollar business litigation cases, that's really what I deal with. So business disputes, not so much on the consumer side, but I am happy to provide guidance on the consumer side. Okay, so even like so superior court matters, not justice court matters? Yes. Okay, all right. Does anybody else? I do have Carol Collins has a question. Carol, do you want to go ahead and unmute and ask your question? Or hold on, let me see if it's in the chat. Okay, maybe that just got left up there, but okay. All right, anybody else have any questions for Rochelle? Okay, again, thank you so much, Rochelle. And for all attendees, I will be sending with your certificate of completion after the webinar, I'll send you a copy of her handout. So thank you so much. And so now I'm going to take back the spotlight here. Who is here, and we're going to get him started. But before we get him started, I want to go ahead and show the second word, the second verification word of the day. As everybody's aware, we have 3 verification words. You want to write these words down, and then at the end of the webinar, send me an email with all 3 words, and I will respond with your certificate
of completion. And so the second word is bag, B-A-G, bag. So everybody, you want to write down that word and remember to send that to me after the webinar. So why don't we, I'm going to, Thomas Alangi is our next speaker. Tom, are you ready, or do you want to take a little break to ask any questions, or are you good to go?
I want Rochelle to come back and keep talking.
Yeah, she's terrific.
No, I'm ready to go. If I mean,
Okay.
with all these video things, people just take breaks when they want them, but I can wait a couple minutes or I can start.
Well, let me make you, I'm going to go ahead and make you the spotlight presenter right now. And so you can take over and share your screen if you anything. Were you going to share?
Your voice broke out.
I'm sorry.
Okay.
Did you want to share anything on the screen during your presentation?
I will eventually, and I can do so right out of the gate. You know, I have my handouts up here on the screen. I had everything brought up on the screen and minimized so I could do that whenever you were ready for me to start. Just whatever makes you and the gathering happy.
To do that. So I apologize. I think my connection is not good. I might switch that in a second. But all right. Well, let's just move on to Tom's presentation. And so our next presenter is Tom Alangi, Attorney Tom Alangi. As I mentioned earlier, he's going to be giving our family law update. And so, Tom, go ahead and take it away.
Thank you so much. I appreciate that. And good morning, everyone. It's a real pleasure to be back again presenting with AAIP. I think it's been, I don't know, about 3 or 4 years, Don. And it's just, it's nice. Disappearing into solo practice will just take the wind out of you. But it's great to be back and doing something other than standing in a courtroom. Just some house cleaning. I just alluded to this a moment ago. Since we're all appearing by video, you know, I'm not blind to the fact that people just generally take water, coffee, restroom breaks whenever it suits them, and that's fine. I'm not even going to keep track of who's logged in and who's not. So don't sweat that. And Dawn, unless you ask me to, I'll probably just keep going from the first hour into the second, unless a 5-minute break or 10-minute break is something that you promised the attendees they would have, in which case just say the word and I will gladly, you know, give that space. When I spoke to Dawn about how to handle this presentation, we kicked around a couple of ideas, and part of me just likes to kind of read and react and answer questions, but I'm definitely dedicating at least the first hour to the core of what Don was looking for, which was to talk about either recent updates in family law or helpful reminders. And that's kind of the spotlight, if you will, on the handouts that you have. You should all have, either now or shortly after this presentation is done, you may receive them after the fact, but I've got a 7-page PDF for you. You'll know you have it because it has my letterhead at the top, and it has a series of sections dealing with different topics in family law. So I'm going to screen share it in a second. So even if you don't have it, you're okay. And then with each topic, each case, I'm going to share some tips and observations, occasionally some polite disagreement with various appellate decisions, which I'm hoping you'll either appreciate and join a lively debate, or just kind of wait and look it up later. But there's some really interesting stuff going on in family court. There always is, just by the nature of the beast. And then when I'm done with that component, you know, we've all, to varying levels, been forced to grow accustomed to the intrusion of technology because of the SARS-2 pandemic. I have colleagues who frankly avoided using a computer like it was the plague for their entire practice, who've been forced to learn how to do Zoom and Teams. The Maricopa County Superior Court, like other courts, I'm sure, has had to, at a frantic pace, adapt by coming up with video conferencing software that lets people actually run trials from remote. And there are some definite pros and cons about that. So I'm going to set aside some time at the end, both, for those who are kind of tech geeks, or at least tech enthusiastic like I am. I can share some interesting ideas, things that maybe you've already tried. And for those who are still really kind of nervous when it comes to new applications and sitting in front of a keyboard, I hope to offer you some reassurance and some solace, and maybe get you enthusiastic about it, because there are some really cool things that you can look into that would make your offices run more efficiently, or at least a lot more interesting. and that's kind of the way it is now, where our whole society is moving at a more frantic pace. There's just a lot of change, and the truth, for better or worse, is that the businesses that cannot or will not adapt are going to get left behind. And so there's just a kind of a core reality here that we're all going to have to deal with. So I'll spend some time there. I also promised Dawn, in fact, I'll probably start with this just to make sure I keep that promise. I promised Dawn I would talk a little bit more about the e-filing system that just got released about 4 or 5 days ago. Now, I'm a Maricopa County practitioner. I'm not blind to the fact that there may be plenty of paralegals here on this call who don't practice in the Valley. But my understanding, my research indicates that this e-filing system is actually broadly applied across the state of Arizona. So I don't think you have to worry about Maricopa County guy talking for a half an hour about stuff that you couldn't possibly care about, because I think it's going to be universal. And then that's going to be it. With any luck, that'll close us right out at 12 o'clock, and then we'll be done. I want to echo something I heard right before Rochelle finished, which is the idea of collaborating with certified document preparers, making the most of paralegal help. I know a lot of attorneys are worried about, the quote unquote intrusion of CDPs and how it's going to eat into my practice. I do not share that view. I have found that making good use of paralegals and CDPs as colleagues, fellow legal professionals, is a really big deal. It's smart, and clients don't forget it. Well, I have several clients who come to my office and are looking for help, and it's obvious to me that, yeah, I could sit down and draft these documents, but it would be a bit of a ripoff, because I know a really good CDP down the street who could do the exact same documents, do them really well. It wouldn't involve legal advice, but they could do it at a fraction of the cost and get the case off on the right foot. And I'm always there when they're ready to actually have a lawyer advise them and guide them through it. I have never regretted having that resource available, not once. And I have had people come back later when they're ready to hire a lawyer. So I am a big fan of the direction that we're going, and I think more importantly, it's necessary. The reality is there are just an awful lot of have-nots in our society who just don't have the money right now to hire legal counsel. So we're going to have to be creative and innovate and look for ways to help the public get through this. These are tough times. So that's my shout out for the CDP. So turning to the e-filing, I'm going to go ahead and screen share, and I think I have the authorization to do this. If I don't, we're going to find out. So with any luck, you're looking at my completely boring, gorgeous Windows blue desktop. And the e-filing program, for those at least who are in Maricopa County, you're probably used to seeing a program that, at least in Maricopa County, was kind of a free filing program. And it looks, excuse me, looks a lot like this. And so, a lot of us used this. It was free. It didn't cost anything. and you would just, file now, and you just type in the name, and when you were done, you would get the option to print a filing receipt, and then if you're expediting delivery to Chambers, you would send the e-filing receipt with the document itself, and then eventually the ISIS system runs it through, and then Chambers gets the regular document. Well, I just saw this in an admin order. They're switching over, close that, they're switching over to this e-file AZ program. And you should be able to see this. I don't know if the fonts are too small. I'm going to try to blow it up here a little bit bigger. Maybe that'll help you. And you'll see over here, so I'm logged in. I've already created an account, which is something you're going to have to do. So there I am, Thomas Patrick Alonji. You can click on, over here, upper right-hand corner, you can click on your past filings, documents that are pending submission that have not been accepted yet. There's an e-filing map. And then over here on the left, for a new filing, the drop-down menu. So I said before, this appears to be an increasingly universal program. So it's not just a Maricopa County creature. In fact, by all accounts, we're kind of joining midstream. But what caught my attention is that the program is available now as of last Monday, and it seems as though it will be mandatory as of June 1st. So I would encourage you, at whatever pace your office is comfortable with, to start getting used to this. I like it. It's a little more involved than the free Maricopa County e-filing for family court. And there is, importantly, you'll want to start accounting for this, like Turbo Court for appellate cases, there is a fee associated with each filing. It's a nominal one. It's about $10, $12, but you're going to want to, in your fee agreements, make sure that you account for who pays that fee. Is it going to come out of trust account? Does the client pay it? Do you offer to pay it as a courtesy service? You're going to want to make sure that, to the extent that your fee agreements don't already provide for this, you're going to want to make sure that they do. Now, this was just an admin order, a memo that I got by email just a few days ago. So who knows whether they're going to accelerate the deadline, move it back. I could not tell from the language of the order itself whether this is something that we're going to have to do to the exclusion of any other method of service, or whether that's simply the way you have to do it if you're going to e-file. That was a little bit unclear to me. And I know that under Rule 43, Family Rule 43, it provides for a number of different methods of service once the initial pleadings have been filed and served. There's, first class mail, there's fax, there's standard email. If they're not already going here, don't be surprised if before long that, at least with legal counsel, that they mandate service through this system. I regard that as being a breath of fresh air. I've been waiting for this for a long time, this business of deforesting the Amazon River, so that we can haul around huge reams of paper. Probably should have gone out the window about 2 or 3 decades ago. But I think once you get comfortable with this system, you'll like it. I can't go much further past this window except to give you an idea of, so if I hit existing case, I need to preserve client confidentiality here. So I was gonna make me do this again. I must have signed out because I talked too much. So I'm logged in. Well, this is encouraging. Oh, great. Okay, so this is the first time this has done this. I've been using this program for 3 days. It must have something to do with my login. Okay. And they may be doing maintenance on this system over the weekend. So anyway, so you log in. For those who've used Turbo Court, it will look a lot like the Turbo Court system. You identify the filer. In this case, it'll be your office. You can save your profile, which I've already done. And then you proceed to the next series of windows which talk about the case. And you actually provide a decent amount of information, which is helpful. It's annoying to put it in at first, but then at the other end of the equation, when you get the printout, it'll have a lot of the information that you need to verify the filing. So you put in, for example, the case number. the type of the document. Those of you who's Turbo Court are going to remember and recognize that, because you have to do the same thing in the Court of Appeals for Division 1. And then, of course, you start uploading your attachments. There's a place to put the proposed order. And I actually think that's important, because I have noticed at least 3 or 4 times now that with the free system that we've been using in Maricopa County, I've had 2 or 3 JAs over the last year, judicial assistants, have contacted my office demanding a proposed order when I had included one with the free e-filing system. And I send them a screenshot saying, here it is. And for whatever reason, those are not consistently going through. So I don't know if I'm seeing quietly nodding heads here on Teams today, but that's another reason why I would encourage you to get used to this program as quickly as you can, because it's here to stay, and we're going to be dealing with it. So let me go back to let me end the screen share for a second to make sure there are no questions in chat. There we go. Nope, just people joining and leaving the presentation. Okay, good. Don, I'm going to assume things are still fine. I'm going to keep talking because I don't see any message or something telling me to shut up.
Everything's going great, Tom. I appreciate it.
This actually happened to me once. I was giving a present, not with you guys, but I was giving a presentation. I must have been talking for like 20 minutes and missed the fact that there was a chat from like almost a half an hour earlier saying, Tom, we can't hear you, dude. And that was a scintillating presentation. So, okay, good. So I'm going to go ahead and keep going. So now to turn to this business of the handouts. So we're going to open the screen again, and we're going to pull up my handouts. And I'm going to magnify it again. I'm using a widescreen here at home, and I've heard that some people can't see the font. So I'm assuming I've got this blown up to like 200%. So I'm assuming people can see it. And if you can't, then let Don know, and he'll shout out and say something. So I want to start with some cases involving what they used to call child custody, legal decision-making, parenting time, relocation, domestic violence. Some of you may recognize some of these cases, but I'm still encountering lawyers, paralegals, and frankly, even a judge or two who is unaware of some of the nuances of these cases, especially if they're recent appointees to the bench. And so I have found that it never hurts to go back and drum home a few points. So I'm going to start with this relocation statute. And for those of you who know, in fact, I'll bring up the relocation law. The joys of doing remote presentations. Okay, so we're going to move this over to the right, and we're going to put my presentation over here to the left. All right, so here's the relocation statute. You've probably all seen it before if you do family law practice. And here in Section A, it kind of offers this preamble where it says, if by written agreement or court order, both parents are entitled to joint LDM, legal decision-making, or parenting time, and both parents reside in the state, you have to give notice that you're going to relocate if you're going to clear across the state boundary, or if you're going to relocate more than 100 miles within the state. And they calculate that 100 miles as the crow flies, not by Google Maps. So it's not a question of how many miles you're driving on a freeway to get to the new home. It's a question of just on a map, drawing a straight line. Is it more than 100 miles? So I always, and I know a lot of people who did too, I always used to read this law as basically saying that you don't ever get into the rest of Section 408 unless these preconditions are somehow true. It just seemed to make sense right here. The thought being, why would I ever go venturing into sections B, C, D, whatever, if right out of the gate, this didn't apply. And the classic example is if you're doing a legal decision-making modification, for example, and one or both parents already live in different states. My thought was always, well, okay, then 408 doesn't apply. You can move wherever you want. You may still have to answer for compliance with the access schedule, but the idea that you would still have to somehow justify the relocation seemed kind of wrong. So out comes this Whiten versus Ward case just about a year and a half ago. And it was a case where a wife left Yuma. They had a child. It was a married couple. She goes off to Boston. She applies for an order of protection. 3 days later, her husband, who's still here in Arizona, he petitions for separation and requests emergency orders, which are granted. And they suspend the mother's parenting time except for supervision, and that it has to be back in Yuma. She remains living in Massachusetts in Boston, but she arranges for the filing of a flat out divorce. And then, so you have all this litigation, and then at the trial, the court grants joint legal decision making, but allows the child to stay with the wife in Massachusetts. And in the judgment, the court basically did exactly what I thought the rule was, disavowed any application of Section 408. Husband takes up an appeal and he wins. And so here I kind of broken this handout into 3 sections, what the facts are, what the legal conclusions are, and I've thrown in some extra sources of law or cases that have discussed the point. And you'll see that recurring format throughout this handout. So the first point, and I've given you page citations too, the court says, you know, that Section A only provides what the rule is for whether you have to give notice. It doesn't mean that the court either doesn't have the right or the obligation to consider relocation factors when deciding whether to authorize the change or the relocation. That seems kind of strange because if you don't have to notify the person, let's say that one parent's already living out of state in Iowa and one parent's still here in Arizona, and the parent in Iowa wants to move from Iowa to Nebraska, right next door. Under Section A, that parent, let's call it the father, he would not have to give notice because it says right there, both parents have to be living in the state. Yet, the matter could still go to court, presumably if mother files some sort of an objection, if she finds out about the move, if she finds out about the move after the fact, presumably. This case seems to suggest that the court can still evaluate whether the relocation suits the best interest of the children, even if notice itself wasn't required. That just seems like that invites all kinds of chaos. And I keep waiting for more case law to develop for situations like that to play out, because my first thought when I read Whiten was, okay, then who is, that kind of defeats the whole point of the notice provision. If a parent has to fear for a judicial review, whether they give notice or not, people are not going to want to relocate. Now, for some folks, that sounds like great news. But there are a lot of people, I mean, our whole country was built on people who relocated and immigrated or moved from state to state. And there are constitutional implications as well. The right to migrate, which doesn't get a lot of play, mostly because I think no one thinks to raise it in the appellate courts. But I'm waiting to see, if there's a case that's going to come up through the courts that talks about that predicament that I just mentioned. What do you do if you don't have to give notice, but then, and so you move, you invest all this money and heartache and buying a new house, you find a different place to go, and then the other party finds out about it later and challenges it in court. I don't even know what that petition would look like, because it wouldn't be a petition to prevent the relocation because it already happened. And I don't know what the court would do with that. I mean, so the court says, no, I'm not authorizing relocation. What, you have to move back to Iowa? So this is, I mean, it's published, it's controlling case law, But I like a lot of new published decisions, those of us in the legal profession, paralegals and lawyers alike, we got to wait to see how it plays out with new cases and new situations and new facts. And I have no idea how they're going to resolve that particular issue. So I added some decisions for your further review. One of them is a case that Whiten itself cited. That this was kind of a progression, if you will, an evolution. There was a case, Gwen Cuomo, that talked about whether the court had the option of reviewing the factors, even if it wasn't obligated to. And the courts have kind of migrated beyond it's optional to it's mandatory. And when Whiten issued its decision, it cited this Berrier versus Roundtree case. And I'll highlight it so you can see it there on the screen. The facts were a little bit different, but it was a case where the mother and father had already had an equal access plan for some time with a preschool child. And then the child hit kindergarten, and there was a dispute about where the child would go to school. And obviously, you can't have the back and forth every 2 weeks from state to state if a child's attending classes. You would have to find some way to designate where the kid's going to go to school. And even in that case, even though one of the parents had either final or sole decision-making authority to choose the school, the Court of Appeals in Berrier, this was a year before Whiten, they said, hey, what we're effectively doing here is a relocation. You're changing the primary residence of the child, no matter who wins this argument. And so the court has to go through the factors of Section 408. So that is something I think you're just going to, I think the advice we need to give our clients until we get some more clarity on this is if you've got a client, no matter where they live, no matter what they're doing, no matter how old their decree is, no matter what, if they're talking about doing really any kind of relocation of substance, any particular distance, you should assume that on some level the courts could become involved, and you cannot depend on this introductory section of 25408 to somehow save the day. And that's my advice and my suggestion for today as far as presentations go is be mindful of this. This de Cormier case just came out 3 months ago. It's unpublished, so I'm sure we all know by now the rule about citing unpublished memo decisions. It's in Supreme Court Rule 111. If you're going to cite an unpublished memo decision in any part of your practice, first of all, it has to be a decision that is from January of 2015 moving forward. It cannot be an older memo decision. And you have to provide a copy of that memo decision, whatever document you're filing that cites that decision. And it has to be a situation where there was no published opinion that already decided the issue you're trying to raise. So I always throw that caveat out with unpublished memo decisions because some people abuse them. They treat it just like it's a published opinion, and you can get into really big trouble both with the court and the state bar if you're not careful with that. So that's why you see unpub in big capital letters so that there's no mistake about this. But it's a case where both parents wanted to clear out of Dodge. Father wanted to go to Massachusetts. Mom wanted to be a Kiwi. She got to be a Kiwi, and it got reversed so that the court could make a Section 408 analysis, which the court had not done. There was no secret that the parties wanted to do these things. It wasn't a question of notice, but in de Cormier, they cited the Whiten decision and said, hey, you've got to do a relocation analysis. So on a fundamental level, there's nothing inherently objectionable about a judge making sure that, if people are going to start trucking around the state or out of the country, that at least we take a look to make sure it's good for kids. But it is going to involve a much greater level of intrusion into what might have ordinarily been routine migrations from town to town or something like that. So just, be careful with that. I'm going to look here to see if there are any questions. Questions. I see people joining. I see people leaving the meeting, but I still see no questions. Okay, good. So then the next case, Gonzalez-Gunter versus Gunter, and this just came out last year in, I think it was August. This was a case, it was a modification of legal decision-making and parenting time. And we all know that the heavy trend in family court over the past half decade, or even a little bit more now, has been to try to do equal parenting time, joint decision-making whenever possible. And again, I'll throw in the thought, that's for better or worse. There are some cases where that's a no-brainer, like, you know, you want both parents involved. And there's some cases where an attorney or paralegal might sit back and think, you know, the kid's not a piece of pie. That person really should not be getting 50% of anything, never mind a child. And so then you have to contend with this, you know, presumption. And the Barron case, and you'll see it cited down here lower, I'll get to in a second. The Barron case out of Yuma kind of stood for the proposition that, look, all things being equal, we have a statutory public policy. We're going to want to see a mother and a father as close to equally involved as we can get them. And if you're going to deviate from that, there better be a reason. Now, the statute doesn't really have a formal presumption per se, but both section 25103B and 25403.02B talk in terms of maximizing parenting time, sharing decision-making, absent evidence to the contrary. And the courts are treating that as a rebuttable presumption. That's what it is. Whether it has that label in the statute, they are in fact treating it as a presumption that you have to overcome with evidence. The question then becomes, okay, how much evidence do you have to kind of pull the court off of that middle of the road into something different? And that's where this Gonzalez-Gunter case surfaced. And this was not a case that involved, there was an allegation of drug addiction later resolved with a negative hair follicle test. There was a suggestion of psychological abuse of the children, you know, verbal and emotional abuse. But there was no allegation of other criminal behavior. There was no allegation of mental illness. There was no allegation of physical violence between father and any member of the family. It was just one of those cases. What struck me about this Gunter case was that when I first started reading the facts, I remember thinking to myself, oh, this is totally getting reversed. You know, mother should not have gotten more parenting time than dad. I see these kinds of cases every day, where a mother or father walks in and says, you know, hey, there's some, you know, psychological abuse. They're making the kid really sad. They're not involved as a parent. I mean, I can't see a show of hands here today, but I bet if I asked how many of you have encountered a case where a client walked in your office and said, boy, that other parent, they're just not a very good parent, and they have lousy bedtimes, and they're not involved. They don't go to parent-teacher conferences, and they're frequently out of town. How many people would raise their hand and seriously think that it would be anything other than 50-50, because the courts just don't seem to get into that sort of thing? Well, this was a case, the worst you could say about father, even according to the Rule 10 advisor, was that father was not engaged, their words, not mine, was not engaged with the children, insensitive to their needs, that he wasn't able to prioritize his children's welfare over negative feelings he harbored toward mother. And there was in the decision an unexplained, unelaborated note that father had, quote, taken the children out of state without mother's permission. We're kind of left to guess whether that taking out of state was an abduction that went on for months. Was it an unauthorized trip to Disneyland where he was back the next weekend? We don't really get to know unless you want to go dig deep on Gunter and start calling the parties who were involved. But it didn't look, there wasn't much talk about it. So I didn't really even get the sense that the taking out of state was something that warranted like a criminal inquiry or something like that. So on the whole, it was a case where clearly it looked like there were issues with father, but if we were all betting people and laying down money, I think most of us would have said, okay, that's probably going to go 50-50 because that's how they roll these days. And it didn't. The court awarded a skewed parenting schedule in favor of mother. Father appealed, and in this appeal, he made the argument, he made two arguments. The first argument he made was that, hey, we have a public policy, section 103B, we've got a parenting time LDM statute, section 403.02B, and both of these demand an equal parenting plan. And Your Honor, the only way we should be deviating off of that norm is if there's some evidence of parental unfitness. And to bolster that argument, the appellant, Father, also cited section 25.411, subsection capital J. And for those who do a lot of modifications, you know that in section 411 capital J, there is talk in the statute about when modification can be done at the expense of parenting time. And I'll actually pull that up. Well, I don't have 411, but I can navigate to it. If you give me 2 seconds here. So if you go to Title 25, and we go to section 25.411. This is the modification statute. And I'm going to blow up the font so you guys can see a little bit better. Okay, and then go down to J. And it says down here, the court may modify an order granting or denying parenting time rights whenever a modification would serve the best interest of the child, but the court shall not restrict a parent's parenting time rights unless it finds that parenting time would seriously endanger the child's, et cetera, et cetera, et cetera. Well, Father leaned on that statute, and I think if I'd been in his shoes, I would have said the same thing. It's like, hey, parenting time rights, you're taking away my 50% parenting time, what the heck? And the Gunther case said, no, actually, you don't have to show unfitness per se to skew the access schedule. You don't have to show endangerment. It's too high of a standard. The law doesn't say that. Both the public policy at 103 and the parenting plan statute at section 403.02, they both talk in terms of evidence to the contrary, that it's consistent with the best interest of a child. The court will maximize parenting time and share decision making. And I was thinking, well, okay, well, how do you get around that statute that talks about, hey, you can't restrict parenting time rights? And the way they danced around that issue, the word dance is my word, not theirs, is they said, look, that section talks in terms of restricting how the parenting time is exercised, not how much you get. So I guess in other words, that if there's a debate about whether parenting time should be supervised and how closely, is it at a professional agency where you got to pay for it? Is it, does it have to be a public place where there are witnesses around? Does it have to be an in-home monitor that either is or isn't paid for? The Gunther's decision suggests, well, they say it, they don't suggest it, that that law, that section J, applies to the court's prerogative to restrict how the parenting time is exercised. It is not a referendum on the number of days that go to mother versus father. And so, again, an interesting case, one where I figured they were going to reverse it. And, I'll confess, I don't know if a bias or just an outlook, I'm not a huge fan of automatic 50-50. I think that in general, I think we're all better off when we look at families as individual, discrete human beings, and that they're not like cookie cutter. But given the way the laws read, I would have thought that Gonzalez-Gunther would have been a reversal and not an affirmation, but they upheld Judge Sinclair's order. So, and that was even though he had a negative hair follicle test. Father ended up with just some rotating weekends, alternating vacations and holidays. So again, for better or worse, good news or bad, the message, the implied message anyway, from the Gunther decision is if you've got a case where your funny bone is telling you your sixth sense, whatever cliche you want to throw in, if your hunch is telling you this really should not be a 50-50 plan, that mother, that father, they've got some baggage, and I think it's going to get in the way of effective joint parenting. I would say that you should not be afraid to litigate that. I mean, apply the same good sense that you always do, negotiate where it's appropriate, try to come up with an agreed parenting plan that puts in safety precautions for the things that are bothering you. But in the end, if the opposing side's saying, nope, got to give me some of that 50-50, and you're thinking, don't buy it, there's an issue here, maybe 60-40, maybe 70-30, whatever, you should not hesitate to take it and maybe litigate it. So I kind of, all the things I just said are kind of laid out here in the legal conclusion, so I'm not going to repeat it because you all know how to read, and I hate it when presenters read from material. So there it is. Now I did some case law research, and these are the four I offer you. I gave you the starting premise of Barron, because I thought it was important to emphasize the point that Gunter kind of works hand in hand with Barron, and I think the healthiest way to litigate these things moving forward is never forget that under Arizona law, we still kind of have that presumption like, hey, we're going to do equal unless you got a darn good reason. Okay, you won't see that language in the statute, but it's kind of my lay person's, smart person's, let's all think cleverly about this. You better have a good reason. And the analogy I like to draw, I don't know how good it is, but if you've got a mother and a father with 3 kids and one kid walks up and says, well, I kind of want special treatment. I want to be able to go on this outing, and I don't think you should let the other 2 go. I think I should be the only one. Why should your parents make you special? You need to have a reason for it. Why deviate? Why not treat all 3 kids the same way? And so any of you who are parents or grandparents probably know exactly what I'm talking about, but just use your common sense on this. If it's a case where the client's like, well, if they're nitpicking at things that are just have no real impact on parenting, if one of them is ranting and raving about the fact that the other now has a new boyfriend or girlfriend and is driving him up the wall, too bad. Unless there's evidence that the person's an axe murderer or dealing drugs out of the basement or something like that, people have the right to move on with their lives. But Barron is still a good case, and it is the fundamental premise that we're looking for equal involvement from both parents, unless there's a reason not to. These other 3 are all unpublished. Again, capital U for unpublished. This Atkinson versus Keith case just came out a month and a half ago, unpublished memo decision. In this case, there was a forensic evaluator, doctorate level, who observed that father appeared to have a sadistic sexual interest. Again, her words, not mine. There was a suggestion by the biological mother that the father had some really unhealthy sexual interests. Yet in the same forensic evaluation, the evaluator said that she didn't think it would actually endanger the child. It didn't pose risk to the kid. And the court still did a disproportionate access schedule. And they cited this Gunter case that, hey, even though the evaluator made these observations that the child wasn't necessarily endangered, there was other talk about how father wasn't necessarily being an effective parent in other ways. Again, the concerns that were noted were things that resonated with me because I like to see kids spend more time with better parents, but it was a case where they affirmed. And then kind of the same thing here, Kennedy v. Kennedy, that came from last December, so it's about 2.5 months old. And it kind of caught my attention because it was a case where, if I remember right, and you can look at the decision. I can, by the way, Dawn, I have all these decisions saved, and I think with the citations, most of the attendees today can probably pull up their own Westlaw account or go to the free site online. But in Kennedy v. Kennedy, you actually had a temporary order that gave father equal time. I think it was a 3-3-1 plan, something weird. It wasn't 5225. It wasn't week on, week off. It was someone took out a slide rule and made it weird, but it was like a 3-3-1 plan. And from the moment that happened, the kids were experiencing distress. They were soiling themselves in school. Their academic progress was going down. They were repeating kindergarten. If there was ever a grade you shouldn't have to repeat, it would be kindergarten, but they were. And then this probably didn't help the smell test, but father kept clearing out of town during his parenting time, and he was dumping the kids into care of his assistants or employees. Not the sort of thing you probably want to be doing if you're making a play for 50-50 parenting time at the time of your final trial, but he did. And so the trial court re-skewed the parenting plan back in mother's favor. And in Kennedy, again, they cited the Gunter decision. And then last, there's this Cash v. Cash case, also unpublished, came out just a couple days before Kennedy last December. And this involved also kind of a relocation argument. Mother was in Kansas, father was here in Arizona. The court allowed mother to become the primary caretaker. And father made the same sort of arguments that Gunter had tried, which was, hey, you know, there's no finding that I'm going to endanger the kids. It's not a question of fitness. Why am I, you know, not entitled to this equivalent situation? And they said, hey, Gunter already covered this. You know, we don't have to find unfitness. We don't have to show endangerment. It's not that high of a threshold. So I'm going to check for questions again. More people joining and leaving the meeting. Okay. All right. So let's go to the next case. Now we've got De Luna versus Petito. I hope I pronounced that right. I'm Italian. I should know better, but I don't. This is a domestic violence case. And the reason I bring in De Luna, even though the case is coming up on a year and a half old, is I am still hearing arguments from attorneys who probably should know better, talking about how to break down the domestic violence statute. And for those who don't live and breathe this stuff, I will pull up the domestic violence statute. So here it is. Oh, I'm sorry. Give me a second here. I need to make this a new window. Okay. We can close that. So here's the DV statute on the right of my screen, and I will expand the font again for you. To be fair, this is not really a well-organized, well-written statute. There's a sequence that they could have used for the analysis that probably would have made it a lot easier to follow. But we're going to break it down here. The legislature has divided the domestic violence statute kind of into two parts, two general parts. There are cases where domestic violence is significant, either because one or more individual acts were really, really awful, or you can have, and this tends to be overlooked, you can also have what's called a significant history of domestic violence. So maybe if you isolated any one or more behaviors by themselves, you wouldn't think, okay, you know, that's not enough to take away custody. But put them all together in tandem, and you start to get a really disturbing picture. Just recurring low-level violence or stalking behaviors or harassment, whatever it is, that just never really goes away. It goes on for like years. This statute was meant to capture both of those. And I think what happens is really serious acts of domestic violence kind of capture the court's attention because they're out there. Like you could have a shooting or a burning or assault with a deadly weapon, just, you know, attempted homicide. You could have those are the big ticket things, the felonies, for lack of a better word. Those are relatively straightforward, you would think anyway. If you got something like that, chances are you can get a court to find that there is significant domestic violence. But if you have, repeated violations of an order of protection, for example, just going on and on and on, as this DeLuna v. Petito case, then you can still cite 25403.03 subsection A, which reads, despite section D, joint LDM shall not be awarded if the court makes a finding of the existence of significant DV, or if the court finds by a preponderance of the evidence that there's been a significant history of DV. That ends the equation. And the reason I kind of pound on that point is I still hear people arguing, well, there may have been significant DV, but he gets to rebut the presumption. No, he or she does not. It is the legislature set aside a certain category of behaviors where they said, if you do these things, if a court is satisfied that you are a significant offender, you're out. There is no rebuttable presumption. The rebuttable presumption applies where the court says, I'm not convinced that it was significant DV, at least how I'm going to define it. And I'm not convinced there's a significant history. I'm bothered by it, but I don't find that it's significant within the meaning of the statute. But nevertheless, you have a series of acts of domestic violence which do still qualify under section 3601. They meet the definition. And 133601 has the list of behaviors that, for example, they use for orders of protection. And then 25403.03D defines which acts of domestic violence fall under the presumption. So you can still have a situation where you have multiple acts of what I'm going to call low-grade violence. I don't like using that word because it almost implies that the victim didn't suffer, and they do suffer. But for the sake of the legal distinction, it's important to understand the disparity. You can have a series of behaviors that don't amount to significance, but still meet the definition of what would be an act of domestic violence. Those are the cases where you have a rebuttable presumption. So the sequence works best when the court first decides, do we have significance? If we do, the flow chart ends, we're done, you can't have decision making. If significance is not implicated, then you go, okay, we have these serial acts of domestic violence, or maybe just one act of domestic violence. It's proven to my satisfaction, it happened. Did the alleged offender, or in this case, the adjudicated offender, give me enough reason to believe that he or she should still have a shot at equal parenting time or decision making, despite this baggage they have dangling around their neck? And that's when the court's supposed to go to subsection E, which lists all the different things that the court is supposed to look at to decide if the presumption has been overcome. And as you can see here, there are 6 of these things. E1 just puts you right back to the best interest test. So even though section E has only 6 criteria, E1 refers you back to the 11 best interest factors. So really what you're looking at is 17 factors, not just 6. So just the important lesson from DeLuna versus Petito is that there are 2 tiers, T-I-E-R. There are 2 tiers involved with the domestic violence analysis, and you cannot get those 2 things mixed up. And what happened in DeLuna was the trial court made findings that, mother had this order of protection, and there were stalking and harassing behaviors going on, and he violated that order of protection after it was granted and served. And so the court restricted father's parenting time, but assigned joint legal decision making. And mother appealed saying, you can't do that. You just decided that there was a significant history of domestic violence, and you're still giving him joint decision making. How is this happening? And so she filed a Rule 83 motion to amend, denied. And so she took up an appeal. And then DeLuna kind of broke down how the statute's supposed to work. So if you're ever involved, regardless of whom you're representing, the victim or the offender, if you're looking for kind of a really nice breakdown of how the domestic violence statute is supposed to be read, this is your case. And I'll say it again, people are still getting this wrong. Not 3 months ago, I was arguing this point with an experienced family court attorney. He's no dummy. And he was still trying to argue it was a shooting and a strangulation. And his client had beaten my client over the head with a steel bottle. And he had been convicted for 2 counts of aggravated assault in criminal court. And he was still arguing that there was a presumption that he had the right to overcome. So I would not normally have reached all the way back to 2019 for published case law. Normally that sort of things become kind of well settled and known to everyone. But for whatever reason, maybe because domestic violence is a hot button issue, it gets people fired up. This still seems to be bothering people. Is that people seem to have real trouble with the idea that you can be categorically barred from legal decision making if your behavior is bad enough. So just be mindful of this case because it's out there. And this DeLuna decision, they even repeat the analysis to make sure everyone's clear. They say that to reiterate. So it's obvious they're trying to lay it out there once and for all so that people will stop getting this wrong. So they're the legal conclusions. And I gave you the spot citation. There's 2 different paragraphs. The initial breakdown is this, I will highlight it there at the bottom so you can see in yellow. There's the initial discussion, and then the reiteration is at number 16. So that's where you go for that. And then, I already told you this one right here, so I'm not going to repeat myself. This third legal point also tends to kind of blow past the radar. And I think it's because there's just been such a huge push, a bandwagon, if you will, to do equal parenting time no matter what. And I have noticed that in a lot of domestic violence cases, even when the evidence is super strong, the courts generally seem okay with the idea that an offender shouldn't have pure equal legal decision making, but they're having a lot more difficulty with the idea that access time should be skewed also. And I think maybe part of that's just human nature. I think we just really don't like the idea of depriving a parent of access to a child. I think on some level people still feel sorry for people and don't want them to lose a chance to raise a child like any other parent. I think part of it is that people have this idea that, well, as long as the violence didn't occur in front of the kid, it's all good. Now the parties are split up, so what's the big deal? We could spend hours talking about why each of those ideas is a myth and a problem and something that educators have been trying to teach people about for a long time, but it's beyond the scope of today's presentation. Just be aware that if this is not just a legal decision-making statute, 25403.03F, and on the right side of my screen, you'll see it here. I'm gonna highlight it. Assuming the violence is proven, okay, capital A, assuming the violence has been proven, the offender is supposed to prove why it's okay to still give him or her the parenting time. The victim does not have to prove the reverse. And yet, again, I think if I asked for a show of hands, if I were to say, how many times have you heard a court or an attorney ask a victim, well, why can't he have equal time? Where's your evidence that it would hurt the kid? You know, you haven't proven, just because he hit you, you haven't proven your case that he shouldn't get his equal time. And that is not what the statute says. The statute says exactly the reverse. It's the harm is presumed. If there is violence going on in the home, and if it is proven, then the legislature has already commanded all of us to assume that it's contrary to the child's best interest. It's right in subsection B of the same statute. And so if you are the one, for your sake, whether you're representing the alleged abuser or the alleged victim, if you're representing the alleged abuser, avoid making this argument, if only to avoid being swatted back by a court, because you don't want to get the burden reversed. If you're representing the survivor of the domestic violence, do not let the opposing side shift the narrative to an argument about what your client failed to prove. It's not your client's duty to show the court that there's still a problem beyond the proving of the domestic violence. So in this case, DeLuna actually tackled both of these things, and they reversed on both grounds. They sent it back down because the legal decision-making order was erroneous under state law, and they also sent it back down on the parenting time issue. So let me check again for more questions or messages.
Yeah, there's a question in the chat. I'm not sure if
I see it. I see it. I knew someone was going to ask this. All right. The question, for those who can't see it, is, with a finding of significant DV in a case, have you heard of the court ignoring the finding and statute after a period of time? The short answer is I've come close to that, and I'll explain what I mean. The case I just mentioned with the shooting, the strangulation, and he admitted to the strangulation, and he admitted to hitting her over the head with a steel bottle. And the shooting spoke for itself. He claimed it was self-defense, but he was convicted for 2 counts of ag assault. That occurred back in 2017. I wasn't even on the case at the time. This is the case that I inherited only last summer, and I'm not even on it anymore. And so as we were winding through, there was this big, long, probably too long of a stretch of time where you had these temporary orders. The judge at a temporary orders hearing made a finding that the violence was significant and denied father a share of the parenting plan. His parenting time was denied, and mother had sole decision making. And then you had this therapeutic intervention that was attempted. And over the course of a couple of years, mother began to sustain criticism for not fully investing in the therapeutic reunification plan. We can all argue all day whether she should have had to do that, whether there should have been any talk whatsoever of TI. Reasonable people might disagree on that point, but the fact is she was catching more and more flack because she was not, keeping appointments. She was, in the view of many, she was hindering the process of therapeutic intervention. And so that's about the point where I joined the case last summer. And then father demanded a new temporary order that would give him legal decision making. And so I filed a motion for summary judgment. And I didn't do it based on the temporary order. We all know that temporary orders are subject to revisit. We all know that people don't always get the chance to present their full case at temporary orders. So this was not a motion for summary judgment on the grounds that there had been an earlier interim order. I filed the motion for summary judgment on the grounds that he'd been convicted in criminal court for 2 counts of aggravated assault, and there was no question about how at least the strangulation and the beating with the steel bottle had occurred. People could and did argue about the shooting, but even the strangulation, that's an aggravated assault, class 4. That short of a homicide, a strangulation is about as near lethal as you can get. And so the judge denied the motion and argued in his ruling that there were still material issues of fact and that there could still be competing evidence about whether there was other domestic violence. And, reading DeLuna and reading the statute, that decision appears to have been an error. There is nothing in section 25403.03A that suggests a time limit. There's nothing there that says, oh, you can come back on a modification later. There's nothing that says, oh, you can come back even within the same round of litigation because you believe that circumstances have changed. What the statute does not answer, and I think would probably result in a dependency, is if both parents have committed significant DV. I'm not talking about the mutual combat stuff that erases the presumption. I'm talking about if you had a situation where both parents had used significant violence on each other. The statute is silent on that. the statute is silent on an expiration or a time period and says nothing about what to do if the other parent has such awful baggage of their own that neither one of them is fit. And again, I think the solution to that's probably a dependency at that point, if things are that bad. And I think, I'll say this parenthetically too, I think that's, to answer the rest of Nicole's question, I think that's probably why so many judges in family court don't want to make the significant finding. And you will see them sometimes, you know, contort themselves in cases where I think if you went down to a local bar and polled 12 people and said, hey, if someone did these things to someone, would you say that's significant? And you'd get 12 drunken cheers. Yeah, that looks significant. I think there are cases going through where if you ask lay people or even people in private who are legal professionals, doesn't that seem significant to you? They would admit to you, yeah, but they don't want to make it official on the family court record because Section A makes it a permanent ban. And I actually think that is an unintended flaw in the statute. I think that by trying to protect victims and shield them from any future LDM intrusion by an offender, they made the punishment, if you will, so swift and so harsh that people don't want to impose it. And so you have this situation that's almost like this circus where people who really ought not to be getting decision making at all, who probably should have been banned, are not getting banned because everyone's afraid to make it a permanent situation. I don't personally share that fear in the worst of these cases. I think if someone does, for example, what this man did, they shouldn't ever be raising kids. Not that I wish them ill. I hope to see them rehabilitate. I hope to see them learn why this was an awful thing to do. But you know, that's just my personal opinion. I'm sure there are plenty of people right here on this call today who would have a much different take on that. So, and then I see one other question, Dawn, and I'll jump on that now from Suzanne. That way, I think it's the only other question. And so don't worry that it's not on DB because we were talking about relocation. Give me 2 seconds to read it and I'll let you know if it's something I can tackle here. Yeah, that kind of veers off topic. It's not a bad question, but maybe, Suzanne, if I could, my contact information is on these handouts. If you could maybe copy and paste that question into an email, I'll try to answer you privately. I'm not trying to shoo you away. I'm not sure that really touches, it's almost as much a child support question as it is a relocation question. So humor me on that if you will, and I'll try to help you if I can separately. Okay? I can't hear you saying yes or no because you don't get to talk, so I'm gonna assume that's okay. So, all right. And then here are the cases that talk about DeLuna. DeLuna relied on Heard v. Heard, a 2009 decision, which kind of stated this principle right out of the gate, that if there's a finding of significant DV, you're out. So this is not new. This has kind of been the rule for, you know, that law was actually passed, I think. They revised the domestic violence statute. I want to say it was like in 2004, 2005. It's been at least a decade and a half that this has been on the books, but people just keep tripping over it. It's really kind of weird. But Heard v. Heard was kind of the first official pronouncement. Hey, if you're significant, you're not supposed to get decision making. Then I have 2 unpublished memo decisions, brand new ones from just last month. There's this Wilkeson versus Springfield case. And I threw that in there because it wasn't your classic one parent abused the other parent situation. It was a case where father's new wife had apparently physically abused the children of the parties, the biological parents. Really heavy duty pinching of the kid, leaving marks and stuff. I forget all the sort of details, but the court never really got into a discussion about it, even though it was raised by the biological mother, who was protesting what the new wife was doing with the kids in father's home. And so Wilkinson reversed, and they sent it back down, and they pointed out that, hey, we're supposed to be giving primary importance to domestic violence, what do you call it, family violence, domestic violence. And so I want to kind of throw the thought out there that it isn't just necessarily violence by one parent against the other. It looks like the trend anyway is that we're going to pay attention if the kid's being hurt on any level by anyone. We need to have a discussion about it during litigation. And then this Crump versus Dobbs case just came out a month ago, also February 2, unpublished. But I thought it was interesting because it was a case where the judge did find that there was significant DV, but tried to walk a middle path. The judge gave joint decision-making, but then vested final decision-making authority with the mother. And the Crump case said, no, you can't do that either. Joint but final is not the same as sole. Joint is joint. And then for those who remember, the Supreme Court actually talked about this issue back with Nycase versus Sundaram in 2019, where the Court of Appeals had basically equated joint but final with sole decision making, and the Supreme Court said no, actually there is a difference. And so if you are litigating, regardless of which side of the argument, just understand that although this is not a published opinion, I suspect it would just be a matter of time that if you try to argue that a DV offender should still be able to have joint decision making as long as the victim has final, I suspect that argument will lose in the Court of Appeals if the opponent decides to run up an appeal. So just if that was kind of a nuance or loophole that you were thinking might work, be careful with that because it doesn't look like it would. So I'm going to look here before I go into community property. We're actually almost done with the legal stuff because I do want to spend some 20 minutes or so going through cool stuff. All right, so any more questions here? Okay, good. Okay, so I got Susan's message. All right, so I'll keep rolling. So community property, we only have 2 more topics to go. Community property, there was a case called Femiano versus Moust. Just came out. This is new, it's published. And it's a case where a married couple purchased a home. You can read it too, it's right there in front of you. You had and you see this all the time, where a married couple will buy some real estate, but because, for example, one of the spouses has way better credit than the other, sometimes the one spouse with the good credit rating will buy just in that person's name alone as a married person, but sole and separate property. And then what often happens is then that spouse will turn right around and deed the property to the marital community. This is something I actually did with my home. But a lot of times that extra step is never taken. The property stays in the name of that one spouse, even though they bought it, quote unquote, together. And then you get a divorce. And then there's an argument about, well, whose house is it? Is it a marital home or is it sole and separate property? And there was a case called Bell Kilburn, came out a long time ago, a good 15 years ago, maybe 10 years ago, that resolved that. They don't care about the reasons for the disclaimer deed. If there's a married couple and if a real estate purchase is made and at the time of the purchase, one spouse disclaims his or her interest in the property by signing a disclaimer deed, and the remaining spouse takes sole title, it is sole and separate property. Then the question becomes, well, okay, but then what if this was purchased during the marriage? What happens if during the marriage, the mortgage is paid down, renovations are made to the property, repairs are made, and it is all done with marital money? Whether it's husband's income or wife's income, we all know the drill. During the marriage, employment income is marital income. So what do you do with this? Normally, if someone brings a house or a retirement account into a marriage, we're all used to the idea that there's an equitable lien that's placed on the separate property of that one spouse. No one disputes that the property still belongs to that spouse, But a mathematical calculation has to be done to figure out during the marriage, how much did the husband and wife as a marital community improve the value of that asset? And they have a mathematical formula, that equation that you're supposed to apply. And it comes out of a couple of cases, Barnett and Dreos versus Renz. This was a case, though, where the property was not brought into the marriage already belonging to one person or the other. It was not an asset where the husband or wife alone had paid down that mortgage as a single man or woman, and then the marital community started making contributions afterwards. This was a case where right out of the gate, the marital community was paying for everything. And in this case, the Court of Appeals in a published decision says, you know what? If it's really that situation, that the marital community paid the mortgage, made the improvements, no separate capital investments from either person as separate property, then we're going to take that equity and the reduction in the principal and the improved value, and we're dividing that in half. There's no reason not to. So even though title remains with that one spouse, that spouse has to buy out the other one, according to Femiano. So, okay, that's the first stop. We're all legal professionals, so we all understand stare decisis, a fancy Latin phrase, basically meaning that, we have to respect precedent, even if we don't like it. We have to, we can't just have this chaos where the rules change every 6 months because a different panel of the same Court of Appeals decides that they don't like a decision, or a trial judge just decides, well, I don't like that decision, so I'm going to ignore it. Our system can't function that way, where we have statutes that give us the basic fundamental laws, and then we have case law that develops all this stuff, so that when we're advising our clients what the law says, we can walk into court with some level of certainty. Okay, well, a case just came out on January 21st. It was amended in ways that won't matter today on February 23rd. So Femiano, the ink hasn't even dried yet. And Saba versus Corey comes out. And look on the left side of my screen, you'll see it there. I can highlight it right there. All the material facts are identical. And they just basically say, well, we depart from Femiano. We're not going to follow it. We don't think it's fair. This is the same Court of Appeals, same division of the Court of Appeals, Division 1. And in fact, in Femiano, the losing side took up a petition for review with the Arizona Supreme Court, which was denied on December 15, 2020. Now, just because the Supreme Court denies review doesn't mean that the Supreme Court, if forced to review it, would necessarily agree with the decision. But bottom line is that Femiano was a published opinion, no doubts about it. It was clear, and review was denied to the losing party by the Arizona Supreme Court. So one would have thought that those were pretty clear signals that this is the way it gets handled. Saba v. Corey says, no, not going to do that. And their words, we depart from Femiano. This is also a published decision. So I don't know what you do with this. This is why I promised you at the beginning of the hour that there would be a moment in the presentation where I would kind of shrug and say, oh, well, I guess just depending on which side you're representing, if you're representing someone who doesn't want the equal division, who thinks that we ought to be using the Dreos calculation, then Saba is your case. If you are representing the party who believes that, hey, the marital community paid all of this right out of the gate, we've been paying ever since, no separate money went into it, why on earth would this not be 50-50? Then Femiano is your boy. And I think this is going to have to obviously get resolved by the Arizona Supreme Court. Now, just last night, I went to Westlaw and I pulled up Saba again to see if maybe there had been a petition for review filed or granted, and I see nothing. Now, I think the time period for filing a petition for review hasn't even expired yet. The decision was amended Feb 23rd. I don't remember off the top of my head what it's either 15 days or I forget what the deadline is for petition for review, is the honest truth. But at some level, whether out of the Saba case or a different case coming down the pike later, this is going to have to get resolved because the two decisions are irreconcilable. There is no way, there is no distinguishing fact. And in fact, the Saba court didn't even pretend that the facts were distinguishable. They just said, we depart from it. We're not following it. So take that for whatever you will. I just thought it was interesting. And then the last topic I want to talk about is disclosure and discovery. This has been a pet peeve of mine for years, so I was really delighted to see this get resolved on some level by the Arizona Court of Appeals. This is a 2018 decision, so again, you would think that this is something that is just not controversial anymore, but I still hear lawyers excusing blatant disclosure violations in child custody cases by saying, oh, Hayes v. Gama, child's best interest, it all gets in because if you keep it out, then we are hurting the children's best interest. And you know, we all had to listen to these arguments for years, even in cases where late disclosure, for example, was really hurting the other side, where they maybe could have put together an argument, a rebuttal case, brought in other witnesses who would prove that the late disclosure was actually dishonest or wrong or just whatever. But that just never seemed to get any play. It was almost like gospel that if there were children involved and there was any talk about keeping out evidence, no matter what the reason, that evidence was going to get in because of Hayes versus Gama. And if you're not familiar with Hayes versus Gama, I didn't give the spot citation there, but I gave you the spelling of the case. For the uninitiated and the mentally healthy, Hayes v. Gama is like a 2003 case where a trial judge had ordered the mother to produce a child for behavioral health services with the court's chosen expert. Mother refused, ignored the order, delivered the child to an expert of her choosing, and the child had therapy or services with mother's preferred choice. And as a punishment at trial, the judge held mother in contempt, and I think we're all kind of okay with that idea, but the court also excluded any data from the new therapist that mother had chosen on the theory that, hey, you violated my order, I'm not going to reward you for ignoring me. And the Arizona Supreme Court reversed. They were okay with contempt, they were okay with financial punishment, but they were unwilling to jeopardize the best interests of the children with a technical step like excluding valuable information about their mental health just to teach mother or father a lesson. And ever since then, there's been this, well, Hayes v. Gama, and it kind of has been used to forgive all manner of sins. And anyone who's been in the situation that I'm describing where you are the person who receives a mound of late disclosure 3 days before trial, and you're like, what the hell? I mean, what am I supposed to do with this? And the other side says, oh, Hayes v. Gama, too bad. You got kind of pissed off after a while. So this Johnson versus Provoyer case, it's published, kind of put that issue to rest. And it was a case where mother had repeatedly violated disclosure rules and deadlines. There had been a continuance, and having not learned her lesson, she turned over, once again, late material. It was a written supplement from her chosen expert, and it was only 13 days before trial. She had made no effort to warn father or the court that this was going to happen, and she didn't even try to get a trial continuance. Father said, no way, this is not fair. Mother says, hey, Digama, and the trial court actually agreed with father and said, no, not going to let you do it. Not getting in. And so on appeal, mother cited Hayes v. Gama, and to its credit, the Arizona Court of Appeals clarified that Hayes v. Gama was never meant to be used to inflict unfair prejudice on a party by withholding late disclosure, which is as it should be. It's not fair And potentially it endangers the children to let in late disclosure that maybe improperly influences the court to make a decision about child custody that it would not have made if it had been fully litigated the way it should have been with early disclosure. So I just thought this was a wonderful case. I don't hear it cited very much though. And I'm still encountering even courts that are still saying Hayes v. Gama, even though it's a late disclosure issue. So I'm not sure, again, how this case has slipped under the radar. It's published, it's right on point, and there's a beautiful footnote 6. And I gave this to you down here. You'll see the highlighting. There's a footnote 6 where they actually address the argument that, hey, yeah, we know there have been other decisions based on Hayes v. Gama that were not necessarily contempt cases, but none of these cases had anything to do with late disclosure. And they even list all the different cases as evidence that they were not disclosure cases. It's a beautiful footnote. Probably should have been in the main opinion, but so footnote 6 is your friend. So my reassurance and my warning today is if you're representing someone and you have this idea that you can just dump material on the other side late because of Hayes v. Gama, don't count on it, especially if the other side knows about this case. And if you are the one subjected to that tactic, don't be afraid to raise your hand and say, no way. Just make sure you make a contemporaneous objection and keep the record clear, because I think there's still a lot of loyalty to this idea that all stuff should get in no matter what. Again, it's beyond the scope of today's presentation, but Don, maybe next time we have this, I can talk a little bit about the strict rules of evidence and what happens when they're invoked under Family Rule 2. Not going to go there today, but
that would be great.
Yeah, that's because I actually have and maybe it's good that I'm not talking about it today, because I actually have an appeal up right now where my predecessor who did the trial invoked the strict rules of evidence, and the judge let in a post polygraph interview, DCS records, police reports, all of them hearsay, and did it under the theory of Hayes v. Gama. So with any luck, I'll have. I hope I win, but we'll find out. So
we're pulling for you.
Yeah, thank you. I want you to call the Court of Appeals and tell them that. We're pulling for Tom, just so you guys know, because everyone knows that'll carry the day for me. Okay, and then so here we got. I just thought I'd throw in some helpful practice tips, because people seem to like that sort of thing. So it's not really case law based. But we all know that in 2019, the Arizona Supreme Court did some pretty heavy-duty revamping of the Arizona family law rules. And a lot of the changes were just cosmetic, more logical structuring, relettering, renumbering, and I really like it. They did a great job. But in some cases, they actually changed substance. I'm going to talk about a couple here. So the first pit stop is under the old rule, the old labeling, Rule 49, capital D and E. And by the way, the quickest way to know if someone is mistakenly citing the old rules versus the new rules, if they're still using capital letters as the subsection, you know they're looking at the wrong rules. So here it is right here. If you see the rule number followed by cap letter, they're looking at the wrong book. Don't be that one who's using the wrong book, okay? They redid it, and now they're using lowercase letters, which actually follows, I think, the federal format, if I remember, unless they changed it too. And they also changed which letters apply. So 49, the old 49D and E used to cover property disclosure for divorces, and then Rule 49, the old Rule 49, capital E, covered debt disclosure in divorces and separations. And those old rules actually verbatim said these apply in every action for dissolution of marriage or for legal separation. I didn't catch this. I'm going to admit this because I think it's healthy. No one's perfect. I did not even catch this change until just 3 days ago. They took out the reference to every action for dissolution of marriage or legal separation, and instead now it says that the disclosure provisions apply unless, quote, there's no property at issue in the case, or the parties have entered into a written agreement disposing of all debt issues. And I remember thinking, well, okay, if they're not married to each other, when would property ever be at issue in the case? The family court does not have Title 25 jurisdiction to do property litigation between unmarried people. They have to go to civil court, small claims court. I don't think that's changed. My educated guess, and I don't know this, I'm going to explore this some more, but I think what they were probably trying to do is accommodate cases where the divorce is done or the separation is done. You got a decree, but now you're coming back because of an enforcement, because of a contempt petition, or maybe someone has filed a Rule 83 motion to amend judgment and asked to reopen the evidence, or maybe it's a Rule 85 motion for relief from judgment, months after the fact. Those are all situations where I suppose you could still have property issues or debt issues, and you would want for people to respect the disclosure rule because they used to be married at one point. That's my best educated guess for why they did this. If that's not why they did it, you got me. I have no idea what they're doing. So I just thought that was kind of interesting. I was actually training my new intern, and we got to that. I was like, yeah, because you'll see here it says dissolution, and I pull up the screen and it's not there. I was like, oh, well, that's embarrassing. So anyway, never hurts to learn new stuff, right? So my next pit stop is witness disclosure. Again, one of my pet peeves. We've all seen it. The law office, that when they do witness disclosure, they give the name of the person, maybe they give you the address and phone number if you're lucky, and then they throw some gem out like this. Oh, Susie Q will testify as to all aspects of all contested issues. Well, that's helpful. Or they'll say, oh, Jim Bob, he's going to testify as to his observations of the interactions between mother, father, and the child, period. Now, put yourself in the shoes of the recipient of that kind of disclosure. Does that tell you a darn thing about what that person is actually going to say? No. And I think it's illegal as heck. In fact, and I talk about this here in this paragraph, our Family Rule 49I, governing witness disclosure, descends from Civil Rule 26.1. For those who are students of history, if you go back to when the family law rules were first created in 2006, they took whole gobs of text from the civil rules and just copied them over and made them family law rules with their own numbers. So there was a lot of unity in the text. But what's happened over time is two things. First of all, family law practitioners and courts have come to understand that there's still some additional fine-tuning that needs to be done to accommodate the uniqueness of family court. It's the reason they created family rules in the first place, was because everyone realized that the civil rules just didn't fit families really well. And as time goes on, this was something that was actually probably foreseeable. As time goes on, I think you're going to see a broadening divide between what family rules say and what civil rules say, as people come to understand, okay, that civil rule, that just doesn't work in family court. We need to have something better, different. Here are some new problems that have come up in family court practice. We need to address them. And so you're going to see, just like if you take a species of animal that's on an island and the island blows up in an earthquake and you have two different islands now, they start drifting apart, these species start evolving into different forms, even though they all came from the same ancestor. And then a couple million years later, they don't even resemble each other. And so at the risk of sounding like a geologist here, I think that this is going to continue, this bifurcation. And as that happens, we'll need to be more and more careful about citing appellate cases that talk about civil rules. You're going to want to make sure that there isn't something new in the family law rule that makes that civil precedent not especially helpful. I bring this up today because the second thing I've noticed is that the civil rules are constantly being amended too, to address their problems. And I have noticed that the family law rules tend to be amended at a slower pace. I don't know why that is, but it just is. The civil, the Supreme Court just revamped the civil rules a couple of times. And one of the problems they addressed was this issue of witness disclosure. And if you look at the history of Civil Rule 26.1 sub A3, there used to be a committee comment from 1996 that kind of laid out, hey, it's not good enough to identify the topic of witness testimony. You need to give a fair summary of what the witness is going to say. What observations have they made about the parties? What, incident did they see? And you don't have to write a novel. The witness doesn't have to disclose everything, but you deserve to know a general idea of what the witness is going to share. The problem was getting so bad in civil court, people were abusing that by using just topics of testimony, that they actually amended the rule 2 years ago. And if you look at Civil Rule 26.1, it actually now expressly forbids the mere listing of a topic of testimony. The family law rule has not been changed that way, but I think it's going to happen at some point down the road, because there's still way too damn many family law practitioners who are playing this game. We're not supposed to be hiding our hand. We are supposed to be playing poker with an open hand. That was the whole point of the Zlacket rules from the early 2000s, with no more trials by ambush, no more Perry Mason, people blurting out confessions from the back of the courtroom. We're supposed to be saying, hey, here's what I got. It's supposed to promote settlement. It's supposed to promote fair trials. No more creepy surprises, no more last minute exhibits. We're supposed to be honoring each other's right to know what the heck's going to happen at a trial. And unfortunately, and I think maybe it's just a disease that comes with being a legal professional, sometimes we're just so darn competitive, we hate the idea of showing our hand. And we need to learn to stop playing these particular games. So if you are working for someone who likes to do that sort of thing, if you have the kind of relationship with your boss where you can pull him or her aside and say, you know what, can we at least share a little bit about what the witness is going to say? I'm not sure this is, sufficient disclosure. I mean, if the attorney says, nope, this is how we're doing it, then okay. If you're an attorney hearing this, stop doing it. If you are the recipient of this kind of nonsense, I encourage you to raise the issue and demand something better than that. Because I think the only way this is going to get fixed is if people raise awareness with the local bench, start drawing that analogy to what's happening over in civil court. There's no principled reason why civil practitioners should get away with this versus family court practitioners or vice versa, because we're all trying to accomplish the same goal. And we all have a common heritage, why these open disclosure rules were created in the first place. So watch out for that. I'm going to skip over this next one in the interest of time, but it kind of speaks for itself. But I did want to bring this up here, because this has also slipped past a lot of people's radar. In the past, historically, and I did this myself, it was very common to serve parties with formal discovery, requests for production, or interrogatories that overlapped Rule 49 disclosure. You're demanding things that Rule 49 already requires. For reasons that are not stated in the rule, they now forbid that. And I've highlighted it for you at the bottom of the page. It's Family Rule 51 sub B1A. And it's the second to last sentence of that B1A. And it says, written discovery to a party may not request information that the party is required to disclose under Rule 49. My hunch is that they did that to stop lawyers from accelerating a court's deadline for disclosure improperly. There may have been other reasons, maybe to avoid confusion, to keep things carefully segregated. But just be aware of this. You don't want to get embarrassed in court. You don't want to have a situation where someone's making it look like you don't know the rules. So if you are drafting discovery on behalf of an attorney in your office, and you know just by looking at it that your discovery demands are infringing upon the Rule 49 material, you might want to throw a yellow penalty flag and suggest to your boss that maybe there's a different way to do it.
So Tom, I have a question.
Yes.
This is Don. So what do you, so do you, when the other party doesn't disclose the information that should be disclosed in the, as part of that process, do you do some kind of do you then motion to enforce that, or do you then do your discovery requests?
Well, and it's a great question. And now I'm not going to skip over the paragraph because I actually was going to, I was actually going to go there. There are a couple of ways to solve that problem. First of all, going back up here, and I'll mark it without highlighting yellow so you can see the difference. Never forget, Rule 49B requires initial disclosures under subsections D through K within 40 days after the response of pleading. So if a month and a half into the case, after the answer has been filed, if you don't have Rule 49 disclosure, the solution is not to try to stick them in the discovery demands. The solution is to pick up a phone and have a polite conversation with the opposing lawyer saying, hey, you were supposed to give me this 40 days out. The final disclosure deadline from the court takes care of final disclosures, but we're supposed to be exchanging this stuff. So Jim Bob, what do you say? Let's agree on a Rule 49 disclosure deadline, a mutual one. I'll get you my initials, you get me your initial disclosure. And then if that gets violated, you go through the same good faith efforts to get their cooperation that you would have gone through if you had done formal discovery. And that kind of ties me to the other thing I was going to say here at the end. Under new Family Law Rule 9, those good faith efforts have to include either a phone call or face-to-face meeting. You can't just do it by email. And I'm still getting